কিছু সব হইল এরিয়া বলা গেছিল কালে বলা গেছে okay and we have to write we have no other option.
This bench is considered for only for this
Yes,
case only.
yes. He's in Mizoram bench.
He's appearing through video conference.
Okay. Before Mizoram. What time?
We can
How much
continue to.
time? Yes.
Please half an hour.
Okay. Yes, Miss Nargis.
Yes, ma'am.
What are the points you urge?
Sorry, madam. My lord, in this case, we have argued. First of all, we argued that they have completed about 10 years, lordship.
10 years.
10 years. So date of arrest was lordship 16, was 6/5/2016. Six five children, they received an information, then thereafter, on the basis of the information, my lord, they rushed to the place of interception, and there they found one vehicle, Scorpio vehicle, 2 persons were boarded, then subsequently lordship, one truck came and 2 persons deboarded, and 2 persons handed over contraband to the
Okay,
place of-
on that issue, you urged on which provision?
my lord.
This 10 years,
10 years, we because conviction.
in the
was-
backdrop of which provision?
Lordship, in this case, 10 years, we argued, lordship, because they are
Because conviction is under?
under 20, lordship, there is some mistake committed by the trial court,
Conviction is under
21C,
21C.
lordship, and
21
29,
and
29.
29. 1 minute.
So,
21C.
lordship, about 20 years,
Right. Sentence 20 years.
lordship. Opium 54.648 kg and morphine 2.060 kgs. And in this case,
Under
lordship,
section 29, any punish sentence is given?
lordship,
Huh? Any sentence under section 29?
only 21, lordship.
No, under section 17C also.
17C and the 21C, because earlier, lordship, we have raised the point. The lordship also made a query to that regard. Lordship.
17C.
Lordship, charge was not framed under 17C, but at the judgment, it is reflected. This punishment was for 17C and 21C, lordship.
Now, on this maximum 20 years punishment under section 21C,
Lordship.
what do you have to say? Why you are saying that completed 10 years?
Lordship completed 10 years, lordship, we are.
Punishment is 20 years.
20 years.
Sentence,
Lordship.
which is maximum under section 21C.
21C also,
Is
lordship.
there any submission on it?
Yes, lordship, lordship wanted to see the charge was framed Under,
No, you have missed the point.
Lordship. We argue on last occasion, highest punishment, he has punished, did the petitioner, appellant were punished for highest punishment, Lordship. Well, Lordship, that is why we argue on section 32.
Not 32, 32B.
32
B.
B.
Quote me in addition to the.
Na, 32. Would B, B to beleg is it? 32B. These factors should be considered. Sorry, 32B. 32B. It is assessment. What did you open?
If I told you that. Minors are affected by the. So affected by the offense one. So effect mahal was likely to be affected. Use of threat
Yeah.
to nine,
I said it was
arms nine. Public office mahal. Minors are affected by the offense. It whole even. It is likely to be affected. It will play society hall. All the minors are used, it nine. When is committed in an education issue, it nine. Social service facility in the immediate vicinity of such institution of faculty nine. In other words, which school students resort for suicide only. The packet often belongs to an organized international or outside Sydney group. We do factor nine. Group will be nine. The fact that offender involved in other illegal activities, it will belongs to organized international crime or any other criminal group which is involved in the commission, it may go to nine. Upon review for a group, it is located with minimum term of imprisonment or amount of fine is prescribed for any of it. Minimum to give us 21 6 10 years doesn't mean to fine two. Mean to fine two. Well, you want to see? 1 lakh, which may extend to 2 lakh. Yeah, they give money,
14 number paragraph. 14 to the
2 lakh is maximum is fine. 2 lakhs maximum is so it will by welcome to the pero solo para que yo para que tú te vuelves a entonces okay. Any previous antecedent?
no, my lord. No,
No previous
no,
antecedent.
my lord. It is mentioned in the final complaint also.
Huh?
Their final complaint also. Final
Where?
complaint. Final complaint exhibited lordship as.
Exhibited.
As lordship. So 46 lordship, page number 247. 247. 247.
Yes, 247.
247, Lordship, 472 also. 47. Lordship will find the antecedents. At paragraph number 17, Lordship,
Paragraph 17.
Lordship, page number 254. Oh, it took also
Not 17.
Yes, the page number 254.
Yet to be received. Well, it doesn't receive.
But no criminal.
Sorab, only Sorab.
Only Saurabh they have mentioned, but others also they have not specifically mentioned in here in the complaint. And to our information also, Lordship, there is no case they could bring during the trial, Lordship.
Okay, this is one. SARS, regarding SARS.
Regarding charge, Lordship, on last occasion, Lordship made a query that charge was on under section 21C,
Where is that SARS, initial SARS?
charge 2, page 2. On Lordship, 3rd March 2017, 21C
Page
and
2.
yes, 21C and 29. Then Lordship, this was altered.
21C.
Yes, Lordship. And 29,
Hmm.
page 2, Lordship.
Then some observation was made.
Subsequently, the 3-1, Lordship, what happened at the time of pronouncement of judgment, it was altered, Lordship, to 17C.
Where is that?
Lordship will find at the judgment, Lordship. Page 144, Lordship. Paragraph 80, 81. Paragraph 81, Lordship. It start from 81.
What is 17C?
Yes. 17C.
Uh,
Hmm.
what was the total
Witnesses.
quantity of
Quantity, Lordship, opium 54.68 kg, and morphine 2.06.
So, you were known, under 21C, come to page 2,
Lordship.
first search. All throughout it is mentioned 54.648 kg of opium. It is mentioned that you are charged with the allegation of possessing 54.648 kgs of opium. All throughout you knew it. It is not that you did not know. Suddenly, at the time of judgment, this thing has cropped up. The question of prejudice with the charge. You have been charged with that. No, yeah. Oh. Is it? So is it your ground of appeal?
One more question.
No, I have asked you. Tell me, is it your ground of appeal?
But Lordship, on the day of judgment, it was
No,
altered.
is it your ground of appeal?
We have subsequently we filed the grounds, Lordship. Not with
Show
the
me which is your ground.
additional grounds we have filed, Lordship. It is in the record, Lordship. Additional grounds with a
In the main appeal, it is not there.
additional ground we have filed, Lordship.
Let me see. No, no.
In additional ground, Lordship,
First,
page,
let me trace your additional ground.
yes, it is page
Is it really filed?
yes. Page 276, paragraph number 9.
Paper book?
It is after paper
Paper
book.
book?
Yeah, after paper book, we have submitted, Lordship.
Huh? We don't see anything.
Continuation of paper book, maybe. Continuation of paper book.
Oops, তবু দেখা না।
নহয়, নপৰে নেকি? Your deal দিলি 276 না? ও আমার পিটিশন দি পেলাই দিছা। মেইন রেকর্ড কি বল? একটু রেকর্ড চাইছি।
We have not
রেকর্ড
found anything like additional ground. Oh, আছে নেকি স্যার? চাব দিব এখন চাব দিব মই বিচাৰি দিব নোৱাৰো আছে নাছে না পিছত নাই বুলি কব চৰি বুলি কব
চেক কৰিম। তোমালোকৰ কপি চাৰ্জ কৰিছে না?
আমি পিছত কৰি বুলি কব আকৌ
কৰিছে তোমালোকৰ?
কোন বিচাৰিছো
পিছত দিছে।
বাকী এইটো দ্বিতীয় এপ্ৰিল মেমো আছে চাই ল'ব দিম
আমার পিটিশন এতে না বেলেগ মেইন ফাইল
স্টিকি নহয় ঠিক দুটা বস্তু ঠিকে হৈছে আমাৰটাও লাগা আমাৰটো লাগিব লেখা লাগিব লেখা লাগিব ৰিয়েঞ্চটো এৰি হৈ গ'ল হাওঁতে নহয় কোনোবাই স্টিকি কৰিছে কোনোবাই হেৰি বুলি কৈছে ঠিক কোনোবাই এটা কোনোবাই তাড়াতাড়ি কৰি থব লাগে কোনোবাই বাকী চব আছে নহয় কিন্তু ব্ৰাউন আৰু কিবা কিবা ব্ৰাউন কোনোবাই ব্ৰাউন কৰিব কোনোবাই ক'ব মইতো খেলা নাজানো ইংৰাজী অসমীয়া জানো কালি ওলাল নহওঁতে ওলাল ভাত কেৰেলা ইংলিছ কি কোনেও নাজানো ভাত কেৰেলা শিৱে সুধি আছে ভাত কেৰেলা
On the day of judgment, 313 recorded by the judge and thereafter pronounced the judgment, Lordship. This was also made a query on that day, Lordship.
মইতো চাহ আছিল ন এইটো ব্লেংক আছিল এটা ফিলাপ আছিল এটা ফিলাপ আছিল দুটা মছজিদবোৰ পিছত আকৌ কৰিলে এইটো হেৰি দেনে কৰিলে নহয় জানো চক্ৰৱৰ্তী চাহে কৰিলে
File goes in. 26/9/2023. I hello. Yes, sir. 360. 360. 360.
After 313,
Yes.
did you file any application?
After 313, because it was
313 of three of the accused
Lordship.
were recorded on 22nd April 2019
Lordship.
on the date of the judgment,
Lordship.
right?
Lordship.
So did you file any application for that?
We have not filed any application, Lordship.
Huh?
We have not filed any application. Black code. What are this one? She wants you. Vita file order नहीं बोलूँगी. 360. 360.
Oh, please. Please. 16 and 16 is seen. Order 6 months, huh? Order 6 months.
Take a marry.
It will actually go to deep ground before opening deep ground. Make sure open for for 8 to 24 deep ground or after opening dark. Deep or dark again.
8 to 10.
Deep or dark.
Again.
Oh. I could work the difference. You means knowledge.
Final additional ground we have found, Lordship, in appeal number 360, it has been flagged, Lordship.
It's not like.
We have flag mark, Lordship, pink color flag. mark. Pink color flag mark.
in true appeal from to appeal. Criminal appeal number
360.
page is running page. Oh. Yes, and any other?
My lord, last occasion, one more queries was made regarding this non-compliance of 52A. Ambale judgment also lordship perused lordship on last occasion.
Yes, then page, I think,
Lordship,
para 30. Let us read once again, para 30.
yes.
Thirty-two.
32,
31, let us see 32, 1.
31. No, there. Thirty-one lordship. Married.
Yes.
At the same time, one must be mindful of the fact that Section 52A of NDPS Act is only a procedural provisions dealing with seizure, inventory, and disposal of narcotic drugs and psychotropic substances and does not exhaustively lay down the evidentiary rules for proving seizure or recovery, nor does it dictate the manner in which evidence is to be laid during trial. It is in no manner prescribe how the seizure or recovery of narcotic substances is to be proved or what can be laid as evidence to prove the same. Rather, it is the general principles of evidence as enshrined in the Evidence Act that governs how seizure or recovery may be proved. Thus, the prosecution shuns the compliance of the procedure under Section 52A of NDPS Act will not render itself helpless but can still prove the seizure or recovery of contraband by leading cogent evidence in this regard, such as by examining the seizing officer procedure, producing independent witness to the recovery or presenting the original quantity of seized substances before the court. The evidentiary value of this material is
Presenting the original quantity of seized substance before the court. It was
Yes.
there.
It was there, but
Ah.
with the independent witnesses, it should be proof. But in our case, no independent witness adduced by the prosecution. The court should consider whether the evidence inspire confidence. The court should look into the totality of circumstances and the credibility of the witnesses being mindful to be more cautious in their scrutiny where such procedure has been floated. The cumulative effect of all evidence must be considered to determine whether the prosecution has successfully established the case beyond reasonable doubt as held in Nuraga. Even in cases where there is non-compliance with the procedure requirements of Section 52A, it does not necessarily vitiate the trial or warrant an automatic acquittal. Courts have consistently held that procedural lapses must be viewed in the context of the overall evidence. If the prosecution can otherwise establish the chain of custody, corroborate the seizure with the credible testimony, and prove its case beyond reasonable doubt, the mere non-compliance with Section 52A may not be fatal. The emphasis must be on the substantive justice rather than procedural technicalities, and keeping in mind the solitary objective of the NDPS Act is to curb the menace of drug trafficking. At this stage, we may clarify the scope and purport of Section 52A of subsection 4 with a view to obviate any confusion. Subsection 4 of Section 52A provides that every court trying an offense under the NDPS Act shall treat the inventory, photographs, and samples of the seized substance that have been certified by the magistrate are as primary evidence. In our case, it was not certified, Lordship. What this provision and list is that where the seized substances after being forwarded to the officer empowered is inventorized, photographed, and thereafter the samples are drawn therefrom as per the procedure prescribed under the said provision and the rules or standing orders, and the same is also duly certified by a magistrate, then such certified inventory, photographs, and the samples has to mandatorily be treated as a primary evidence. The use of the word shall indicates that it would be mandatory for the court to treat the same as primary evidence if twin conditions are fulfilled, being that the inventory photographs and samples drawn are certified by the magistrate, and the court is satisfied that the entire process was done in consonance and substantial compliance with the procedure prescribed under the provision and its rules or standing orders. Even where the bulk quantity of the seized material is not produced before the court or happens to be destroyed or disposed in contravention of Section 52A of the NDPS Act, the same would be immaterial and have no bearing on evidentiary value of the inventory, photographs, or samples of such substance that is duly certified by a magistrate and prepared in terms of the said provisions. We say so because subsection 4 of Section 52A was inserted to mitigate the issue of degradation, pilferage, and theft of the seized substances affecting the trial. It was often seen that due to prolonged trials, the substance that was seized would deteriorate in quality and completely disappear even before the trial could proceed. By the time the trial would commence, the unavailability of such material would result in a crucial piece of evidence to establish possession becoming missing, and the outcome of the trial becoming a foregone conclusion. The legislature, being alive to this fact, thought fit to introduce an element of preservation of such evidence of possession of contraband in the form of inventory, photographs, and samples, and embedded certain procedural safeguards and supervisions through the requirement of certification by a magistrate, which is now contained in subsection 4 of Section 52A. In other words, any inventory, photographs, or samples of seized substance that was prepared in substantial compliance of the procedure under Section 52A of NDPS Act and rules or standing orders thereunder would have no mandatorily be treated as primary evidence, irrespective of the fact that the bulk quantity has not been produced and allegedly destroyed without any lawful order. Section 52A of subsection 4 should not be conflated as a rule of evidence in the traditional sense, that is, it should not be construed to have laid down that only the certified inventory photographs and samples of the seized substance will be primary evidence and nothing else. The rule of primary evidence or best evidence is now settled. In order to prove the fact, only the best evidence to establish such fact must be laid and adduced, which often happens to be the original evidence itself. The primary evidence for proving possession will always be seized substance itself. However, in order to mitigate the challenges in preservation of such substance till the duration of trial due to pilferage, theft, and degradations or any other related circumstances, the legislature consciously incorporated the subsection 4 in section 52A to bring even the inventory, photographs, or samples of such seized substance on the same pedestal as the original substance, and by a deeming fictions has provided that the same be treated as primary evidence provided they have been certified by a magistrate in a substantial compliance of the procedure prescribed. This, however, does not mean that where section 52A has not been complied, the prosecution would be helpless and cannot prove the factum of possession by adducing other primary evidence in this regard, such as by either producing the bulk quantity itself or examining the witnesses to the recovery, etc. What section 52 A of subsection 4 of the Evidence Act does is it creates a new form of primary evidence by way of deeming fiction, which would be on par with the original seized substance as long as the same was done in substantial compliance of the procedure prescribed thereunder. However, the said provision by no means renders the other evidence in original to be excluded as primary evidence. It neither confines nor restricts the manner of proving possession to only one mode, that through such certified inventory photographs or samples such that all other material are said to be excluded from the ambit of evidence. Rather, it can be said that the provisions instead provides one or additional limb of evidentiary rule in proving such possession. Thus, even in absence of compliance of section 52A of the NDPS, the courts cannot simply overlook the other potent evidence in the form of the seized substance itself or testimony of the witnesses. Examine all that the courts would be required in the absence of any such compliance is to be more careful while appreciating the evidence. In the present case, the only ground that has been canvassed by the appellant herein is that section 52A of the Act and Rule 10 of the NDPS rules 2022 has been contravened in as much as the investigating officer had allegedly mixed all 73 packets of seized contraband together and thereafter proceeded to draw two samples of 100 to 100 grams each from the mixer. This, according to the appellant, renders the accuracy and reliability of the samples as doubtful. The said grounds is being reproduced because then 39 the High Court is in its impugned judgment and order rightly rejected the said contention on the ground that it was nothing but the said allegation and there was nothing to events such contravention. Having gone through the material on record, we are in complete agreement with the reasoning of the High Court, although from the testimony of PW 15, the officer in charge of police station where the seized substances was forwarded, it may appear that the seized substances were simply mixed together with the. This is regarding the new act, new rules, Lordship, regarding 2020's having mixed together following the procedure of segregating similar packets of same quality and nature into lots and thereafter taking representative samples therefrom. Yet a closer reading the trial court judgment would reveal the police officer where herein had duly followed the procedure prescribed to the letter and spirit. As per clause 2.5 standing order 1 by 89, and the relevant standing order in force at the same at the time of seizure where multiple packages or packets are seized, they first have to be subjected to an identification test by way of a color test to ascertain which packets are of the same kind, weight and contents. Thereafter, all packets
So,
which
Krishna Agis, 52A is a procedural step
Lordship,
for photographing, inventorying, and drawing samples.
Lordship.
This judgment also says that even if that procedural safeguard is not there, meaning that by certification of magistrate was not there, samples were not drawn. But if the process of search and recovery inspires confidence, and right from very beginning up to the end, the seized contraband are satisfactorily preserved, and evidence inspires confidence, then court can proceed. Right. Mere non-compliance of the procedure under section 52A will not be fatal to the trial unless there are discrepancies in the physical evidence rendering the prosecution case doubtful. Right. Now here you raise the question deep brown, dark brown. I don't think deep brown, dark brown are different. Perception may be different, but there is nothing. Orange has not become blue, or blue has not become yellow. It is deep brown, dark.
And one powdery substance in 52A.
One only.
One.
One shade. But all are sticky. All are say sticky.
But Lordship, we have made one more condition on
Search and seizure, yes, search, recovery, seizure. All are NCB witnesses.
NCB witness, independent witnesses.
How independent witness non-examination? Because we have seen how it was closed.
Yes.
Now tell me, what prejudice has been caused?
My lord, only the
It's
PDF
non-examination
that is
of independent witnesses.
no, not only that
It
only,
is a rule,
Lordship.
thumb rule, that non-examination of the independent witnesses who witnessed the search, recovery, and seizure would be fatal to the prosecution case.
My lord, only PW3 is the witness here, Lordship. He is the seizing officer. He collected all
So
these things.
my
That is why
my question is
Mm,
purely
that-
different. Miss
I'm
Nanak.
trying to
Please
Lordship,
hear me out.
Lordship, Lordship, Lordship,
Don't go on a different tangent.
Lordship, Lordship.
I have said the proposition is non-examination of independent witnesses who witnessed search, recovery, and seizure
Yes.
during the trial would be fatal to the prosecution case. Is it the proposition?
And
Yes or no?
my lord,
Or it depends on facts to facts?
depends on the facts to facts.
Okay. Next proposition. In the absence of independent witnesses, though they were present according to the prosecution,
Yes.
right?
Yes.
Examination of the police witnesses, or say NCB, or DRI,
Prosecution witness.
right?
Yes.
Investigating authorities witnesses.
Yes. Lordship.
Regarding their testimony about search, recovery, seizure, if it inspires confidence, is it not sufficient
to bring about a conviction? What is the law? So it depends on the facts of the case. It is neither a settled proposition of law that if only police witnesses or NCB or DRI witnesses were examined regarding search, recovery, and seizure, then prosecution is false. It is not a settled proposition.
Yes, case to case, depends upon the
Even
case.
though we have seen independent witnesses not sticking to their versions
Yes,
because many times they are won over. We have seen, miss,
in so
it is not
many
to be
cases,
denied.
Lordship.
They say lapse of memory, right? Many things happen. But if the prosecution witnesses belonging to the investigating authority stick to their versions, and if it inspires confidence, and no independent witnesses were examined regarding search and recovery, will it be fatal in all cases or it depends on facts to facts?
Depends on
Right.
facts to facts. Because normally in NCB DRI cases, this witness cannot be owned over by the accused person.
I cannot be said. Everything is possible.
But Lordship,
Everything is possible
everything is possible,
or everything, nothing can be ruled out
Lordship. But
in
in
a better way
Lordship,
to say,
Lordship,
right?
in this
So it is your 52A, non-compliance,
not complied,
non-compliance
Lordship,
of 52A, right?
Lordship.
Now 52A is inventory, photograph, drawal of samples,
And list of
certification,
list of samples.
list of samples, right? Samples. That under subsection 4, it will be treated as a primary evidence, right? On the other hand, it is a universal rule of evidence that if the seized quantity in bulk is produced, that is the exact primary evidence. And there are so many cases of opium and morphine, all were produced before the trial court. In this case,
In this case,
is it yes or no?
yes, yes,
Then at your insistence, 1 or 2 bags were open.
Lordship.
Then that issue of sticky or brown,
Sticky and
Brown.
powdery substance.
that issue you raised.
Hmm.
But at your insistence, primary evidence was
Had to do
open. So this is one. We have to examine that. Second charge. Third, 313. Fourth, completed 10 years. 32B.
Lordship.
And charge and 313. That is on the date of the
Yes, judgment.
313 on the date of the judgment.
Yes, Lordship.
And change of charge in the judgment,
Yes,
right?
yes.
And any other ground?
This is on a 52, in 52, Lordship, Lordship,
We have even
Lordship,
yes,
Lordship judgment is there, Lordship.
yes,
Regarding certification
Yes.
and all this, Lordship, though.
yes. That was not the sole ground.
Yes,
There were other grounds.
yes, yes. Other
That was
some.
not
other-
the sole grounds.
Yes, yes.
There were other grounds also. Now here, one more is independent witnesses are not examined.
Yes.
Right?
Because punishment is under NDPS Act is so stringent, Lordship.
Yes,
That is why.
stricter the punishment, stricter is the compliance.
Yes, yes,
Right?
yes.
Then any other ground?
Though Lordship, in Apex Court held in one case, Lordship, though the physically produce all the contraventions before the trial court, even it should not be considered as a primary evidence, Lordship. In
Oh, no, where? It cannot be. Let us see.
I took.
If you see Amble,
Yeah, Ambale.
Ambale,
Yes, Ambale also.
Ambale, you come to paragraph,
Paragraph.
and I believe that is always true. Paragraph
Mhm.
37.
Good.
Page may be, I don't know, the primary evidence
Yes.
for proving possession
Yeah.
will always be the seized substance itself. And paragraph 37 has been beautifully explained. There is no doubt about it.
একটু নিন। একটু সময় হয়েছে, use everything, সময় হয়েছে।
Okay.
Going to do this.
This was just different.
একটু আলেট, একটু ভাগ্যে ভিজে গেছে। প্রথমত যদি সার্চ রিকভারি সিডার sample, then depositing it in Godown, then placing the Godown board, again back to the Godown, and plus samples were immediately forwarded to the office. And there was no change in the chain of position, and it is beyond doubt. Then that can be acted upon. Number 52A, non-compliance to Godown. If that is so, it will be পুলিশ করে দিল তাৰপিছত নেচাৰ হেৰিটো চেঞ্জ হোৱা নাই ষ্টিকি ষ্টিকি আছে ব্ৰাউন ব্ৰাউন এক্সপাৰ্টে কৈছে মাত্ৰ আপোনাৰ FSL 154 to South page 154 to South never 152 152 it was our material exhibit sticky 1 2 3 4 5 6 7 1 2 6 hole opium আৰু 7 to hole morphine use sticky এটো হল তাৰপিছত আপুনি 154 FSL টো চাব এইটো match section it নহয় এইটো হেৰি opium morphine লিখা আছে এইটো opium morphine লিখা আছে এইটো সিহঁতে প্ৰথম হৈ যায় Yes, তাৰপিছত আপোনাৰ FSLৰ হেৰিটো চাওক এক্সপাৰ্ট জন হৈ যায় FSL expert
FSL expert is PW1, Lordship. Lordship will find page number 3.
কি কৈছে এইটো ওটো টেস্টিং
So page 3,
Yes,
he described the article samples pasty
yes,
and only morphine powder.
yes,
Only morphine powder.
yes.
I don't know. I have not seen neither. I have not seen morphine. So I don't know.
Morphine, actually, it's a
Only
powdery
difference-
substance.
Only difference is come to page 50, 152.
52.
There is some mention is sticky. Sticky, dark brown sticky. Dark brown sticky,
Yes.
it says. Serial number 7. Now let us see when you insisted for opening of the bag.
Page 33. History কি question?
Page 32.
33. Hmm? 32 diagrams, yes.
Dark brown sticky,
Lots,
is it not?
lots.
So both are dark brown sticky. It is consistent. Deep brown, dark brown, I don't think
Lots.
there can be. Somebody will, and somebody is saying pasty, somebody is saying sticky.
Sticky.
Somebody is saying dark brown, somebody is saying deep brown.
Mhm.
So for except morphine, powder, one says, another says sticky.
But we are on that, Lordship. If
You are
a
on?
question raised, if non-compliance of section 52 is there, then it is the duty of the prosecution to
Do you know harakiri? You insisted for opening of the packets,
two packets,
2 bags.
bags.
Perhaps that amounted to harakiri. Mr. Choruri. There are many Hindi phrases also. Or what is it? There is also another word, boomerang. You know the instrument? Boomerang?
Boomerang.
In Assamese, in Hindi, also look into 32B
Yes.
because there is no previous conviction or previous arrest, at least
Yeah.
on records.
Lordship, on that part, Lordship, already
But
we have
all throughout, right from very beginning, it has been at the time of seizure, Panchnama,
yes.
FIR or complaint, charge, testimony, evidence. Everywhere it is mentioned that opium and morphine,
Yes.
2 point some kgs of morphine. So whereas 17C, the court is powerless or not powerless, right? We have to examine that aspect.
Yes. Sir.
Anything more? I
Uh,
am saying once again, independent witnesses, non-examination. 313,
Lordship.
17C, non-compliance of 52A, right?
Lordship.
Then
32B.
32B at last,
Last. If
alternative,
if we fail
right?
in this, Lordship.
Alternative.
Lord. Sir,
Any other ground?
Lordship,
I have listed 5.
this,
Lastly, 10 years,
10 years.
32B,
Yes.
right?
Yes.
So independent non-examination of independent witnesses, then questioning search, recovery, seizure, drawing of samples,
Lordship.
non-compliance of 52A,
Lordship.
313,
No.
last on the last date
Last.
of the judgment,
Lordship.
change of search 17C, without there being any charge earlier? Anything more vital?
Two decks that
Dark brown, deep brown, sticky, non-sticky, powder. Tell
Lordship.
me
Lordship.
if there is anything more. We
No,
have
Lordship.
noted all this.
Lordship, on this regard, I have completed my argument, Lordship. Today was fixed for his argument.
Okay. We have refreshed. We
Yes.
have refreshed
Yes.
ourselves.
Lordship.
Okay. No, yes. We have spent half an hour,
Of 1 hour.
1 hour. We cannot throw it because there are other matters. There are other matters. We cannot wait because others, because you two are the only counsel for this division bench.
Yes, yes.
Others are waiting for a single bench.
Yes, Lordship.
Why not? Something. Yes, Mr. Jain. Not possible.
They could have
You could have-
informed us, Lordship. If
Huh?
it was not possible on their part, they could have informed us
No.
at least.
No.
Could
Many a
inform to
times
the-
within 1 minute bench falls. Many a times it goes for the entire day. You can
Yes.
predict.
Problem, nothing.
Last 2-3 occasion also
Scott-
they have taken time, Lordship.
এখন আরো ঘুরাই দিবে।
একটু তো দিতেই হবে। নেক্সট উইক তো দিতেই হবে। Yeah, August to the 14 numbers, subject to our availability. No, it done over to areas. It done over to areas. I don't work. I think because of the. I don't think they go there, but like this. Huh? I didn't know. So we don't work on some person. Who pays our rate to get our rate to on the and I've taken on. Taken on. I've taken over. Taken over. I've taken over possible no. Not going out to put me Bhagari. Biswariba.
We put it on 14th August. Because next week we don't know. Always subject to availability or
See. Actually, we were like to point.
My lord, let them assure that they will be available.
that
on it.
assurance which is very, very difficult. Okay. Alright, yes, can Nargis Learning Council for the appellants. Full stop. The prayer is made on behalf of Mr. S.C. Kyle Leonard. He will probably proceed direct by next. Orders to nine. Standing council. For the respondent NCB. To post the appeals on another date on the ground of personal difficulty on his part. Post up. As sought for and agreed to by the Learning Council Board of Parties. Raised the appeals on 14/8. The appeals are likely to be taken up at 2 p.m.
Lordship, I'd like to mention for listing tomorrow, criminal revision petition mail. I filed it yesterday. What happened, my lord, on 26th of July, order has been passed by executive magistrate directing me to hand over the key to respondent number 4. My lord, on 30th of July is the date for compliance, tomorrow, my lord.
Okay.
Obliged, my lord.
Criminal appeal 2016, sir. Item 20.
28.
28, okay, 28. Okay, 22. On the prayer of Mr. N.J. Das, Learning Council for the petitioner, release the appeal after a week. PP. Let it be after a week. Hmm? Next week, next week.
May I please, your lordship? I beg to mention a criminal revision which I filed yesterday, my lord, and we listed on tomorrow, my lord.
Tomorrow there will be many,
On Thursday, lordship.
no,
After-
Friday. What is the prayer? Monday. Friday.
Item number 8 here. Passed over. Okay.
8,
Item number 8,
yes.
pass over. Tomorrow or day after,
No, we'll pass over for the race will fix. On the prayer of Mr.
our corner.
R. Kumar, Learning Council for the petition, the case is passed over for the consent. $26. Mr. T. Chetty on Learning Council, appearing for Mr. A. Ganguly, Learning Council for the petitioner. This is against 2014. You wait for your turn. 2014 matter will not adjourn.
President, I beg to mention item number 11, the arguing the council as per transport station. may be
Item number
11,
11, yes.
after 2 weeks.
After 2 weeks. Okay, on the prayer of Ms. P. Bora, Learning Council for the petitioner, lays the case after 2 weeks. Next week. Motion. Orders. Court martial will give the date.
I beg to mention for listing of a criminal appeal for order circuit. And
For?
behind the bar, lordship.
Production.
For order circuit.
For orders. Give it for a court master, court will fix the date.
May I please, my lord? My lord, I'm praying for listing of a criminal petition. This has been filed on Friday, my lord. My lord, on the 1st of August, this matter has been fixed for appearance in the lower court. I'm praying that can this matter be fixed tomorrow in the supplementary list, my lord?
Friday.
My lord, on Friday itself, can it be on Thursday, lord?
Friday, you say it is listed before the High Court.
Yes, I oblige, my lord.
May I please, your lordship, I beg to mention item number 15, my lord.
Yes.
And guest counsel, he could not come today due to some personal difficulties. And guest counsel R. Sonar.
Lordship, in this matter, I am the respondent number 2 appearing through VC. The petitioner has no right of audience in this matter, Lordship. He has played fraud on this court. Kindly let the matter appear. Lordship may hear me for a moment and then decide on the adjournment.
Okay, there is an objection.
Lordship.
Item number 15. There is
Lordship.
an objection.
Serious fraud has been played on this court, Lordship.
You wait for your turn.
And Mr. Basumatari is on the cause list, Lordship. His name appears. He is
Okay.
already there.
Okay.
Oblige, Lordship.
Lordship, I beg to mention 2 criminal petitions for withdrawal.
Your lordship, I beg to mention for listing a criminal appeal and behind the bar more than 1 year
Yes, for what?
for orders.
Lordship, kindly pass over the item number 6 for the day.
Okay, on the prayer of Miss
SR Das.
SR Das, learning council for the petition. The case is passed over for the day. Consent, PP.
Lordship, kindly fix on 6 August.
Pass over for the day.
Yeah, please, your lordship. Firstly, I'd like to mention for listing of a criminal petition for admission column, my lord.
Give it to the court master.
So,
May it please your lordship. Lordship, I beg to mention item number 16, which is listed in the admission column. State matter, my lord, there was a medical board report called for. As the colleague has informed me that has not come, my lord.
Okay, Mr. D. Boydo, learning council for the petitioner is present. Mr. D.P. Goswami, learned additional public prosecutor, has submitted that the medical report,
Medical board's report, my lord.
medical board's report, comma, as called for, comma, has not yet been received and has sought for listing of the case on another date. Full stop. As sought for by Mr. Goswami. When? Okay, list the case on 12th of August.
My lord, the interim may be
The interim order passed earlier shall continue.
deeply obliged, my lord.
Next one.
may it please, your lordship. Lordship,
Yes.
I'd like to mention for listing a criminal petition for motion for Friday, lordship.
Friday,
Lordship, motion, lordship.
heaven will fall if the case is listed on Monday.
Lordship. On Friday, lordship.
Whether heaven will fall if the
No, no,
case
lordship, no,
on Monday.
Monday. Oblige, your lord. For withdrawal, 7:33.
36. Supply niki? Yes, madam.
Lordship, as per instruction from the client, Lordship, we want to withdraw criminal
Okay,
petition.
Miss Anne Chaudhary, learned counsel for the petition, has made a prayer for withdrawal of the criminal petition as per the instructions received from her client. Full stop. You were there? Or? Okay. Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, State of Assam, and Miss K. Malakar, learned counsel for the respondent number 2, who are present, have submitted that they have no objection to the prayer for withdrawal. In view of the above submission made by M.H. Chaudhary, learned counsel for the petitioner, the criminal petition is dismissed on withdrawal. Full stop. I ask in view of the order passed today in the connected criminal petition, criminal petition number so and so, the instant interlocutory application stands accordingly dismissed
Lordship,
on withdrawal.
Trial court record was called, can copy.
Scan copy,
Yes.
originally is there.
Yes, Lord. Oblige.
7.
Yes, madam.
Lordship, kindly matter withdraw.
Your name, please.
P Kakoti.
T Kakoti.
P Kakoti.
P Kakoti.
Appearing on behalf of MS.
MSP লিখি দিব senior counsel.
Yes, sir.
Okay. লিখি দিব আগৰটো নিচিনাকে only PP. Mr. D.P. Goswami লিখি দিব
Item number 38.
EA.
Lordship, regular bail application, my lord. Offense under section, my lord, 318(4), which deals with the
384 of BNS.
BNSS, which deals with the
Where
my
is
lord, cheating, my lord.
384?
And 308, which deals with the extortion.
Huh?
My lord, FIR is page 13, my lord.
Page 13.
Page 13.
Page
May I read,
13.
my lord?
1 minute.
I have the honor to inform you that on 26/6/25, based on the FIR submitted by the complainant Hazrat Ali, a case was registered at Obhaypuri Police Station, Bhait, Obhaypuri PS case number 140/25. under section 108.
What is 108, Mr. Borua?
No,
Huh?
108 is the abatement of suicide.
Okay.
That is another case, my lord.
And,
Fairness. In this regard, the officer in charge of the station assigned me the case for investigation of the same. During the investigation, I arrested and forwarded the FIR name accused person, Kuddus Ali, that FIR name accused person. Son of late Hektullah Sheikh, village Dantola, Noyapara, PS Obhayapuri, district Boyagaon, and has been already forwarded to the Honorable Court, North Sharmala, Obhayapuri. During the courses of this investigation on 14 July 25, I got to learn that the two individuals mentioned below demanded total amount of rupees 4 lakhs from the two FIR name accused of the aforesaid case, namely Soli Sheikh, son of Heketullah, village Dhantola, Noyapara, PS Obhayapuri, Boyagaon, and Dilbar Ali, son of Kasem Ali, village Fulkamari, PSN district Boyagaon, using my name and the name of Honorable SSP. The money is not paid SSP Bongaigaon for the purpose of excluding their names from the case, and if the money is not paid, then they would be arrested and forwarded. Subsequently, I inquired the matter and confirmed the matter to be true and have collected an audio recording in which a demand for money was made using names. Hence, the below mentioned two accused persons are involved in criminal conspiracy in order to extort illegal money of their personal gain, my lord. This is the allegation. Now, my lord, kindly see the page, my lord, 24. That FIR, my lord.
So you are using the name of police?
My lord, that is the allegation, but
Allegation when audio recording is also there.
subject to your lordship permission, I would like to submit few lines in support of my lord. Page 24, that FIR, my lord. There is three accused, my lord. Got it, my lord, 24 page.
Page?
24. This case was lost against three accused, my lord. Kuddus Ali, who is the main accused, already arrested.
Page
So-
24.
24.
It is an order
My lord.
dated 18/7/2025.
24 is the FIR, my lord.
That is your order remanding to custody, bail petition rejection. To go on bail.
There is some misplaces there, my lord.
That is your misplace. That is
After
your.
some time, my lord, I want to go through the record. After some time. After some time. 39 also same FIR, my lord.
But if I have to approach this honorable court for granting of maintenance in favor of the wife under section 125(4) of CRPC. Basically on the ground that the petitioner is a police constable and he used to work in different districts of Assam, and he married with his wife in 1987, and thereafter he kept his wife in the house.
1987.
87. 97.
Now
97.
97 means
97.
28 years of marriage.
Yes.
Yes.
Lordship, thereafter.
Wife has filed maintenance.
Lordship. Fact of the case, Lordship, after his marriage, he used to reside in different places because of posting. Petitioner kept his wife along with his old mother and brother. Thereafter, Lordship, the 3 children were born, and petitioner loved them together and lived together. But after some time, petitioner's wife started living with his brother of the petitioner. And they have admitted that she is at present also living with the brother of the petitioner. Petitioner has filed a petition for divorce in the family court. After filing divorce petition, she has filed a DV case in the court of CGM. Ultimately, she has agreed that she will come back to his petitioner and she will live together as husband and wife. But thereafter, she did not come. Thereafter, Lordship, they have filed a case for maintenance under section 125 with the family court. Family court, Lordship, before family court, there is a village settlement. And village settlement also, they have agreed that she will stay with his brother and he will not live with the petitioner. Ultimately, Lordship, mutual agreement was executed for that they will not live together, and they have separated themselves. Everything has been settled. Now, Lordship, this honorable court has granted, after giving evidence, mother also had this evidence, that she is living with his brother, and honorable court granted maintenance in favor of her. Children I am giving Lordship. Last payment was made rupees 1 lakh. I have paid in 2025. Lordship, kindly see. Page 28. That is a deposition of the wife of the petitioner. Lordship, got it?
Yes.
Page 28. Middle portion, Lordship. It is not true that, Lordship, got middle portion. Lordship, got it? Page 28. It is not true that in that case, I stated that now I am in my mother's house. I am in family court counseling was happened. In that counseling, my mother-in-law told that I have been living with Utpal Das and we both together eat rice. Lordship, got it?
Next line is also,
Same.
no, denied.
Next time is denied.
Co-habitation with Utpal Das.
Lordship,
Next to next line, also
Thereafter,
denied.
Thereafter, Lordship will kindly say page 29. That is the son, that is the daughter Purobita's evidence. Page 29.
My father used to assault my mother by such.
These are allegation, false. I'll place, Lordship.
Falsity is different.
Lordship, that is different thing, Lordship. Page 29 again.
It is a matter of appreciation by the
Lordship.
court only.
That is well, Lordship. Page 29. That is the daughter's evidence.
Clear evidence, categorical, second para.
Lordship. Purobita's evidence, Lordship, in page 29.
Yes, second para. My father used to assault.
Lordship. Now page 30. My mother and grandmother together cooked their meal in the side of the room.
Which
Door, page 30.
Cross.
My mother and grandmother together cooked their meal in the side
My
room.
father.
My father and grandmother
Huh.
together cooked their meal in the side room. Door connecting our room with my father's room was closed by placing a sofa near the door. We are unable to open the door due to sofa. My father is a working police. Due to his works, he has stayed outside his house for many days. At the time of grandmother, uncle, mother used to stay in our house. My father used to bear all expenditure of our school and houses before the incident. My uncle constructed a house at the backside of our house near the main road. My uncle is unmarried. Next, also, all villagers know that my mother stay with my uncle. My father stated the fact before everyone. I and my brother now stop our father.
We have to, long evidence, we have to appreciate the entirety.
Lordship, then-
Entirety
at
picking
which-
up one line or two line will be difficult.
So cross-examination.
At this
part only.
stage.
Now, Lordship will kindly see page 32. Next, daughter's evidence, Dolly Das. Page 33, cross-examination. Before this case, my father loves me and my sister and my brother. Our school fees also paid by our father. My father also loves my uncle. My father and grandmother eat together. My grandmother cook. My mother, uncle, my sister and my brother, I ate together. My uncle made beautiful house in the backside of the near road. My uncle was unmarried and till now I did not move into the house. Before the incident, the next paragraph, before the incident, my father loves me, my mother. I know that my father do not drink alcohol and smoke and cigarette. Now, all these necessities are done by my uncle. I go to school by cycle. That cycle was purchased by my uncle.
Mr. Goswami, you cannot pick up one line or two line here.
No,
from
the
there.
cross-examination part. Only evidences was given by the Lordship, the whose daughter, that she is living with his uncle. Now I will take your Lordship to the next paragraph. Not single paragraph, Lordship. Huh?
We'll issue notice at this stage.
No, only thing is, Lordship, kindly see two things.
This Utpal Das was a party in the 125 proceeding.
Because 125 was
No,
filed
no,
by the
but
wife.
I am asking you, this Utpal Das was a party in the 125
No,
proceeding,
no.
then we'll not issue notice to him.
Because Lordship,
No,
that
no, no.
petition was filed by the wife. I cannot implead.
Me joined your party in this criminal petition. How can it be?
Only Lordship,
Meet.
considering the judgment passed by the Supreme Court, I have made party in this particular case. Because the
What
person
Supreme-
against whom
what
I
Supreme
made
Court has
the
said?
allegation, against whom I made a allegation, without hearing him, no order can be passed. That is why I made him
No,
party.
did you make him party there?
I cannot make Lordship because it is a 125 proceeding filed by the wife.
No, will not issue notice at this stage.
Before that, Lordship, kindly see. I want to show the something, Lordship, that is, Lordship, kindly see. Joint petition could have. Before that, page 21, kindly see the joint petition filed by the magistrate by both husband and wife. Page 20.
Things may deteriorate thereafter also.
No, no, Lordship, joint petition by the husband and wife.
When?
Page 21.
During the course of the proceeding.
Before the Lordship, the
DB
proceeding.
case was closed or
Before
what?
the DB proceeding.
DB case was closed.
Closed on the basis of this petition.
When it was?
It was closed on 2016.
Then 125?
125 thereafter.
Well, issue notice at this stage, Mr. Goswami.
Lordship, kindly see one thing, Lordship. I do not like to, Lordship, praise. Generally, I do not like to give all these things. Lordship, kindly see page 125 again, page 21 again, Lordship.
On page 21. Page 21.
Page 21. This is a joint compromise petition.
The question I have asked that when it was closed, 2016. Thereafter, 125 was in 2017.
Because after withdrawing this petition has been withdrawn, stating that they will live together as husband and wife and make a cordial relation. And
Thereafter,
thereafter did not
things
come
may
back.
change also.
He did not come back.
People change with time. I had Mr. S.K. Goswami, Learned Counsel for the petitioner. First of, in this revision petition, the petitioner has assailed a judgment and order dated 26/5/2025, passed by the Court of Learned Principal Judge Family Court number 1, Kamrup Metro at Guwahati in FC Criminal case number 462 of 2025. So stopped by the judgment and order dated so and so, the Learned Family Court has granted, has directed the petitioner, who was the opposite party in FC Criminal case number 462 2025, to
Page 102.
pay monthly maintenance of rupees, paragraph 14, 6,000 to the petitioner's wife and a comma, rupees 2,000 to one daughter till she got married in the year 2023. 4,000 to the unmarried daughter and rupees 2,000 to the son till he attains majority, with effect from the date of filing of this case. Post of Mr. Goswami, Learned Counsel for the petitioner, has referred to the testimony of a number of witnesses to point out that the petitioner wife has left the company of the petitioner and started living with the younger brother or the petitioner, who is made the respondent number 2 in the instant revision petition. First of, the matter would require consideration, issue notice, returnable in 4 weeks, as the respondent number 2 read herein was not a party in the proceedings of FC case number so and so, this court, at this stage, comma, is not issuing notice to the respondent number 2. So the petitioner shall take steps for service of notice upon the respondent number 1 by registered post PTAD as well as by usual process within 3 working days from today. The prayer for interim relief will be considered, is left open for consideration after appearance of the respondent number 2.
Before that, Lordship,
One.
Lordship, only one thing. Kindly see page 74 again.
Page
74.
4.
74 is the starting point of the evidence. 74. I, my mother, my younger sister, and younger brother stay in the house of Utpal Das from year 2014. Khura loves me like his own daughter. Utpal Das bearing all our expenditure, food, clothes, education, etc. Boundary wall between my house and my father, Khura, people cannot cross over the road. Everything has been clear, Lordship. And she has admittedly she is staying with uncle. And Lordship, mother of the petitioner also give evidence to that effect that she is staying with his brother.
We'll see to that.
Only thing is, Lordship, if see, I'm paying maintenance to my son and daughter, not to her because of this. If she had agreed that I'm staying with me, then nothing happens. But she is staying with his brother and live together as husband and wife in front of the people. People of the locality has given evidence that she is staying with his brother. Because of-
Have you sought the dissolution of the marriage till
Lordship,
date?
I have filed a petition for divorce that was withdrawn on the basis of the compromise that they live together as husband and wife. Considering the children, they want to compromise this matter, they live together. But she has not come.
Okay, at the time of hearing, we'll see that. Matter of appreciation or evidence.
The appreciation evidence is on record, Lordship.
Okay,
Evidence
next.
on record. My submission will be, Lordship, if Lordship, I have
Yes,
already,
matter of appreciation of evidence only of the record. We cannot go beyond the evidence beyond the record.
Lordship, that is the evidence on record, Lordship. That is the evidence before the family court.
We'll examine and appreciate at the time of hearing.
Obliges.
May I please lordships. This case, my lord, the criminal petition for quashing, my lord, the charge sheet and the proceeding in PRC case, my lord.
What is your prayer here?
In this case, my lord,
Mohan, charge sheet. And incident proceedings of PRC case numbers. Yes, FIR.
yes, sir. So, my lord, I have annexed the, my lord, a copy of charge sheet, my lord. What happened, my lord, in this case?
Why you have not annexed the FIR?
Well, I could not obtain the FIR, my lord. The only charge sheet is.
So you are also not sure about the full case.
My lord,
On the basis of FIR, charge sheet you have
one
annexed.
photocopy is there, my lord. But that is not, my lord, clear. That's why I have not annexed, my lord. One obtained, my lord, but So-
An FIR to effect that on her husband on proceeding from the residence on by riding a motorcycle. And when he reached at village 108 Kwang near French. Another vehicle proceeding for the same direction. Then a knockdown and the leader was the kind of Yes.
yes, my lord. In this case, my lord, what happened in the year of 2022, my lord, one motor vehicle accident took place, my lord, wherein the present petitioner was the driver of the offending vehicle, my lord. And my lord, accident took place at night hours, my lord. And
What is your ground?
my lord,
I have read the charge sheet. What
Yes.
is your ground?
my lord, ground is that, my lord, that immediately after, my lord, lodging the FIR, my lord, the as a result of the said accident, my lord, the present petitioner was also sustained grievous injuries, my lord. And the other person, the husband of the respondent number 2, he was sustained injuries and thereafter, my lord, succumbed to his injuries on the same day, my lord. And thereafter, my lord, after lodging the FIR by the respondent number 2, my lord, some amicable settlement took place in between the parties. And the, my lord, driver is from Borpeta, and my lord, the respondent number 2 is from the district of.
There was only one driver,
Yes, my lord.
Abdul Hanan,
Yes, my lord.
Maruti
Yes, my lord.
car.
And my lord, he was the, my lord, riding the scooty, my lord, and the deceased person, my lord,
Yes.
deceased one. And after the accident, my lord, the family members and the relatives of the present petitioners approached to the, my lord, respondent number 2 and his family members, as because this petitioner also sustained grievous injuries, my lord, and is surviving, my lord. And on sympathy, my lord,
Mr.
Yes, my lord.
Ahmed,
And we
I
are
have heard you.
and now, my lord, the respondent number 2, my lord, is not intended to proceed the case, my lord.
I have heard you.
My lord. But in this respect, my lord, this honorable High Court, my lord, has passed
No,
already, my
we
lord.
do not want to proceed beyond the motion stage in this case.
Then, my lord, issue notice, my lord.
No, we are not going to proceed beyond the motion stage. Full stop is here.
My lord, otherwise, my lord.
Heard, Mr.
My lord,
Ahmed.
in this case, my lord, I'm submitting, my lord.
No.
This honorable court has, my lord.
When the charge sheet was submitted?
My lord, Sarsi submitted, my lord, on 2022.
2022.
My lord, yes, my lord.
Yes. What is the stage of the trial?
This now, my lord, stage is my
Stage of the
appearance, my lord.
trial?
Fixed on, my lord, 4925, my lord. For appearance, my lord.
For appearance. You appear. Heard, Mr. S. Ahmed, Learned Counsel for the petitioner, and Mr. R.J. Borua.
My lord, in this.
Learned Additional Public Prosecutor for the.
Pardon, my lord.
Cannot be a ground that you also sustain. Definitely
My
two
lord, other things-
vehicle collided. One would definitely sustain injury.
My lord, some other grounds is there, my lord.
No ground. Negotiation is not a ground. A person died. We know the other agendas also. Ms. R.J. Borua, Learned Counsel, Additional Public Prosecutor for the respondent number 1, State of Assam, full stop. The petitioner has sought to invoke the inherent powers of this court available under Section 528 B and SS 2023 for setting aside a charge sheet dated 28/2/2022 submitted in connection with Moran Police Station case number 26/2022. Full stop. The first information report. The first information report was lodged by the informant Uddeswari Karmakar on 14/2/2022 before the officer in charge, Moran Police Station, stating inter alia that at around 9:30 p.m. on 25/1/2022, while her husband, Ranjit Karmakar was proceeding from Moran towards his own residence at number 3 Madhakali by riding a motorcycle, page 10 also, bearing registration number AS-06/N-6648, the motorcycle collided with a vehicle bearing registration number AS-15/IY. Yes. Wrong typing, sir. AS-15/N-1399. Martika. Proceeding from the same direction. Full stop. it transfers that the Maruti car collided the motorcycle, hit the motorcycle from behind at a place near village 108 number Khwang Grant near Kareng Dhaba on National Highway number 37. Full stop. The affair alleged that the Maruti car was being driven at an excessive speed and in a negligent manner. And it knocked down the motorcycle rode by the husband of the informant from the backside. So as a result, Ranjit Karmakar sustained serious injuries on his head, chest, and other parts of his person. Though Ranjit Hazarika was taken immediately after the accident to a government hospital, but the doctors there declared him as dead. Para. From the charge sheet, it further transfers that during investigation, statements of witnesses were recorded. Finding sufficient materials against the petitioner, who was the driver of the Maruti car. He was arrested and thereafter allowed to go on bail. Finding sufficient materials against the petitioner for committing the offences under section 279 IPC and section 304A IPC, the investigating officer submitted the charge sheet under section 173(2) CRPC by charge sheet number 13/2022 on 28/2/2022. Full stop. In the charge sheet, 8 number of persons, 8 number of 8 number of witnesses. Names of 8 numbers of witnesses are listed to bring home the charges. Post of para. The instant criminal petition is preferred on the ground that in the said accident, the petitioner also sustained grievous injuries on his person. Post of. After the accident, the family members and relatives of the petitioner approached the informant of Moran Police Station, case number 26/2022, to settle the matter amicably. After negotiation and out of sympathy, the informant agreed to compromise the case, and subsequently, the matter had been amicably settled in between the petitioner with that of the informant in presence of elderly persons of the locality. Nothing has been brought on record to substantiate the matter of negotiated settlement between the petitioner and the informant of Moran Police Station, case number so and so. Not even the first information report lodged in connection with Moran Police Station, case number 26/2022 has been annexed with the criminal petition. On query, on query to the counsel for the petitioner, it is submitted that the trial of the case has not yet proceeded, and the case is at the stage of appearance of the petitioner as the accused. Having regard to the parameters laid down settle parameters laid down for invoking inherent powers of this court under section 528 BNSS within bracket earlier, comma, section 482 Code of Criminal Procedure 1973, comma, as settled by the decision in Fazanlal versus so-and-so 1994 supplementary SC, SSC supplementary 435 niki, comma, we don't find any merit in the instant criminal petition. Full stop. Consequently, comma, the criminal petition is dismissed.
Oblas.
I have. And the question petition, my lord, kindly see the page number 21. Page number 21.
Yes.
Yes. May I read, madam?
Yes.
Petitioner is present, opposite party is respondent. Petitioner means my lord, this person number 2, my lord, here the main petition, present petition. The opposite party is represented today is the fixed for the necessary order. The opposite party filed petition number 290 dated.
Petitioner on, you are a petitioner.
No, my lord. Yeah, this petitioner, my lord, is the resolution number 2, my lord. This is the order of the my lord, Planet Tile Court, my lord.
Yasmin, okay, petitioner.
Yes, my lord.
Opposite party filed petition number 290.
Opposite party.
The means
Now
the petitioner.
Yes.
Okay.
Opposite party of the Lanet Tile Court. Here, my lord, the petitioner, my lord.
Yes.
The opposite party filed the petition number 290 dated 26/3/2025, stating that the petitioner on so 1/11/2022 filed a petition under section 120 of CRPC taking the maintenance against the opposite party. The said petition was registered Miss case number so and so 45 of 2022. This further stated that the 21/12/2023 the case was fixed for the evidence of the petitioner. However, the petitioner did not produce the evidence and express her willingness to settle the matter amicably. It is also stated that the petition that on 6/1/2024 both parties appeared before the court learned SDGM as Soraido, and the petitioner compromised the case. According to the learned SDGM as Soraido had order dated so and so disposed the case. Now in the instant petition, it is further stated that the petitioner has withdrawn her case, that is Miss case number 45 of 2022 under section 125 CRPC. And it means that the petitioner has voluntarily abandoned her the claim as such the any next phrase matter. Any the petitioner to take her the back, not to provide any maintenance to her. The opposite party by filing this instant petition, being petition number 290, has contended that the petitioner by withdrawing the previously instructed case has abandoned her claims for future maintenance as well. Now it is present pertinent to mention that here the Miss case number 45 of 2020 under section 125 CRPC was withdrawn by the petitioner on certain terms and conditions agreed between the parties by date of mutual agreement, and the same does not amount to waive the petitioner's right of the seeking maintenance from the opposite party. Further, the Miss case number 45 of 2022 was disposed on the compromise between the parties and not on the merits. As per the revealed contentions of the petitioner, the terms and conditions of the aforesaid agreement was not honored by the opposite party, and that the opposite party has failed to maintain the petitioner. The instant case has been filed by the petitioner seeking maintenance allowance from the opposite party, alleging that the
Yes, I have read.
my lord, first of all, my lord, the present petitioner, when the petitioner so first wife
read.
on the so and so, after that he is living the alone, my lord. After that he married the second of the petitioner.
Where is the law that subsequent petition after amicable settlement due to subsequent cause of action?
No, that
Subsequent
mutual, my
petition
lord, that
under
mutual
125
agreement
is not maintained.
executed by the both parties, my lord. It's
Huh?
not two both parties. That mutual agreement executed by the both parties. That's
Yes, that
two
was in 6/1/2024. And this petition is preferred subsequently.
Subsequently. in the-
125 proceeding
My lord.
was preferred, again, it
Same-
was
same year,
initiated, yes.
Same year, my lord. My lord,
Okay.
that mutual agreement executed for the conduct of the conjugal life, my lord.
Okay,
But the petition, but the S1 number 2 did not go to the her maternal house, my lord, for conjugal life, conduct the conjugal life.
you established
My
it.
suddenly, my lord, suddenly filed again, my lord, second time the maintenance case, my lord, without any valid reason, my lord.
Okay,
Till now, I am ready to restore the conjugal life, my lord.
okay, you restore. You restore.
Yes, my lord, I am ready to.
Yes,
That is why,
Mr.
my lord.
Purva. Not repair. Nothing wrong. Absolutely nothing wrong. And correct order. We should not perpetuate. There is nothing which debars the respondent number 2 to prefer another application under section 125
There must
due
be
to subsequent cause of action.
subsequent, my lord, there is a immediate.
Show me the law that
No, no,
there is debarment under the law.
New service is created, my lord. In between the.
Show me the law that there is debarment. Because your petition is that on the same ground is generally barred.
Yes. Without going to the petitioner house, my lord, so to conjugal the.
There is no bar. Show me.
But yes, I am I am ready to continue the rest of the
Okay,
conjugal
good
life.
enough.
My lord, again and again, my lord.
Good enough.
The maintenance case, my lord. It is
Okay,
just
good
addressing
enough.
the
Take
petitioner,
back.
my lord.
Take back. Don't try to misuse the provision of law. Hard, Mr.
My lord, can't the issue the notice, my lord, S1 2, my lord.
Oh, no. We are closing it. Closing it.
Without any assault
We
by
don't
the
find
petitioner
to
the
invoke
S1
our
in
inherent
the
power
between,
in
my
this
lord,
case.
the after before the filing this second time maintenance case, my lord.
Okay.
There is no assault by the petitioner, my
We are
lord, to the
imposing
S1 number 2.
cost also then. We will impose exemplary cost also. No merit, absolutely no merit in this case. Region order, well region order, 17/6/2025, page 21. Absolutely well region order. There is nothing to interfere with this order. Yes, heard, Mr. S. Raman?
Then, well, I am want to withdraw, my lord. Please, withdraw.
Yes. S. Raman, learned counsel for the petitioner. And Mr. R.J. Bodwal, learned additional public prosecutor for the respondent number 1, State of Assam. After hearing the learned counsel for the parties at some length, Mr. Raman, learned counsel for the petition, has submitted that the petitioner wants to withdraw the petition. In view of the above submission made by Mr. Raman, learned counsel for the petitioner, the criminal petition stands dismissed on withdrawal.
My lord, withdraw. Oblige.
Lordship, on the other day, I was asked to furnish the copies of 207, the statement of the witnesses to the learned government I have given. I may be permitted to Lordship, place before the copies with typed copy.
What, SC/ST Act or what? Which one you want? No, I am still questioning that.
No, Lordship, we have been charged 207, whatever the offense explained is beyond any implication of the petition. There are 11 witnesses. None of them has implicated us in this
No,
case.
first we have to be clear.
That's it.
Taking of cognizance by Chief Judicial Magistrate is your submission?
That is one ground, Lordship.
No, both cannot go together.
First,
That is the initial point.
mainly we are on the framing of charge against us, Lord. The offense should
Where
have
is the
been
charge
explained
framing
against us.
order? Where is the charge framing order? Order framing charge?
Lordship. This is Annex 48, Lordship. Page 48, Lordship.
Page 48. All.
There appears prima facie material to presume that all the 8 accused persons committed offense under section 147, 341, 353, 323, 506, Accordingly, particulars of aforesaid offences are read over and explained to the accused persons, in reply to which they pleaded not guilty.
Yes, Mr. Goswami,
Lordship.
whether this video report, CFSL Kolkata,
Yes, that has not been received as per the.
Lordship, I have
And
the
other
Xerox
things, my
copies,
lord.
Lordship, given.
Huh?
I have in the Xerox copies, Lordship, the 207. Here was at page 22 and page 24, Lordship. Non-acceptance of this materials by the CFSL Kolkata. There are two reports, Lordship.
Page
Page 22 and 24, Lordship.
Yes,
This is one part, my lord, regarding the evidence, my lord, video footage, my lord. If you log,
it is not ultimately,
because
it is not there.
it is not in the, my lord, because.
It will not be part of the evidence.
Yes, but
It
that,
looks like. Have you
Yes.
seen this to document?
yes, my lord, regarding,
Okay.
yes, my lord, non-acceptance, that part.
Non-acceptance.
Yes, that is one part, my lord.
So that is gone.
Yes. In other things, my lord, if your lordships perhaps gone through all the witnesses, my lord. So far, all the witnesses are concerned, my lord. They are corroboration of my lord statements with all the my lord complainant
But not
plus his
named,
drive
not
plus-
named.
is named, my lord.
So it is only against MLA is not where
MLA,
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 MLA
and
and-
logor kejon man.
yes, logger, my lord, your lordships. if
Is
I
there
say-
any TIP?
no, Lord.
So far, this is the eyewitnesses version, my lord, of all the persons present there, my lord. They stated that the assault was made by the MLA.
Obviously,
MLA.
there are many accused,
Yes.
including the
MLA.
MLA.
After that, my lord,
MLA has been named by all.
yes.
And
Yes.
few of the statements
Yes.
indicate that town logor bureo
Logor
gali
bure,
galas
yes.
kore khedi
These
hai,
are the, yes.
something like that.
Yes, Khedia hai,
Right.
and they what the.
But they are
actual-
not named.
Not named, but they are persons, that is why, my lord, they are the persons. It was not named in the FIR, my lord, first, my lord.
In FIR, may not be, may
Yes.
not be,
Yes,
right?
yes,
May not require.
yes,
They have pointed out MLA and the other person,
yes,
his companions or
Yes,
accomplices, whatever. But during the course of investigation,
yes,
at least there should have been some kind of identification, because nobody has named anybody, any of these petitioners.
yes, but as per the, my lord, yes, that is as per the search sheet, my lordship. Finally,
RCT has
Yeah.
mentioned many things,
yes, as 31. So,
but this IO was not the place of occurrence.
as per the, my lord,
The witnesses were at the PO. They could
Yes.
have said so.
uh, they might not be knowing all the
Is
name of
there
the
any TIP?
name of the person.
Was there any TIP?
EIP as per the search sheet, it is not there, but
Huh?
as per the search sheet. My lord, here প্রেরণ করে যদিও ইতিমধ্যে
Even they have say they
Yes.
are granted.
প্ৰেৰণ ৰিগাৰ্ডিং FSL প্ৰেৰণ কৰা হয় যদিও তেওঁলোকৰ কোনো ফলাফল পোৱা নাই ইতিমধ্যে পদকীয়গণ ক্ৰমে মিজানুৰ ৰহমান দেন আনিছুৰ
All the
Then
others.
all the persons' names were, my lord.
Sir, I
They
can
are my-
understand, all have
Yeah,
been
my lord.
identified from the video footage.
Yes, my lord.
Right.
Right, my lord.
Now, this video footage,
Yes.
I think it is not, will not be admissible under the Evidence Act.
My lord, yes, my lord, but so far this,
Or whether there is a certificate.
yes, for whether there is a. It is
Whether
only
there is a
stated, my lord,
certificate.
regarding that, it is only stated, my lord. If you
It has
are-
not been come, lordship, no FSL report, lord.
Report has not come, my lord. It is stated that
Even not,
currently,
No, why?
currently, my lord, as per the, currently the resources and are not available, but that can be made available, my lord.
already 7 years has already been elapsed.
Currently,
No. Question is 65B,
yes,
earlier Evidence Act, that is
Lordship.
regarding certification.
lordship.
But law is also there, that it is a secondary evidence.
Secondary.
Primary evidence is available,
No TIP, lordship, no
not
identification.
required. If the primary, the video footage, if the entire thing, if your mobile, it has recorded, then if your mobile is surrendered as the evidence, it is primary evidence.
Yes.
Law is clear.
Yes.
Those are 65B is a different thing. But whether there was seizure,
Seizure is there, my lord.
what was seized?
Only the pen drive, lordship.
Ah.
From the PW 12, the last
Who
witness,
have-
Suraj Mahato.
Who has made the, my lord, that,
Ah.
The last witness, even they did not name, lordship.
lordship, may I kindly say page 30.
So as then pen drive cannot be accepted.
One ScanDisk pen drive that
Hmm,
was, my
It is
lord,
there.
provided by Aliul Islam,
Yes.
who has made the video recording, my lord.
Pen drive is there.
And he has made the categorical statement in the 161, my lord.
Question of genuinity will come at a trial.
Trial, lordship, doc identification normally not problem. Lordship, it has to be first TIP should be there for the first time. Doc
No,
identification.
that
lordship.
is a matter when this new
So,
technologies were not
Lordship,
there.
in the FIR even, lordship, FIR even itself mentioned the 15 persons.
The police has listed the accused in the charge sheet primarily on the basis of the video footage. It could be easily inferred because the statements did not indicate any name. It is the only pen drive. Pen
That-
drive.
That to support. it,
Now,
65
tell me
said-
that pen drive standing alone cannot be accepted as evidence.
Yes, Lord.
That's all. Then, if it is not an evidence, trial, unnecessary trial.
That is our.
See,
submission.
Yes.
these statements did not mention any name,
Not mentioned, my lord.
right?
Yes.
Only evidence
Yes.
on the basis of which the IO has named and listed these persons in the search sheet
Yes.
is the video footage.
Yes.
Now, it was sent to CFSL. They did
Yes.
not accept.
Yes.
Now, this seized scan, that scan disk, pen drive,
Yes.
can be accepted as an evidence, primary evidence.
Yes.
That's all. If not, then gone.
Without certificate, it cannot.
No,
Even the pen drive was
No,
placed
no, no.
without any certificate.
no, may not be. Show me. I have some doubt there.
65B, lordship.
65B is secondary evidence. Here,
Camera should be the primary evidence.
no, camera, with camera, yes, camera
That
is,
should be the primary evidence, lordship.
no,
And the evidence that police seized not the camera, only the pen drive. And that is the statement of the witness.
let us see the last witness. Last witness.
মোৰ উক্ত দৃশ্যাৱলী পেন ড্ৰাইভত আছে আৰু সেইটো পুলিচে জব্দ কৰিছে
1 minute.
সুৰজ মাহাতো
Last one, I think, photographer. Photographer.
সুৰজ মাহাতো লৰ্ডশ্বিপ
Oliul Islam.
Aliul Islam, my lord.
হি ষ্টেটেড মোৰ লগত থকা ৰিপৰ্টাৰ সুৰজ মাহাতোৱে উক্ত দৃশ্যখিনি কেমেৰা কৰি লয়
সুৰজ মাহাতো মই কেমেৰা ৰেকৰ্ডিং কৰা ভিডিঅ'গ্ৰাফি চালো চালে সকলো গম পাব উত্তৰ দিশা বুলি এটা পেন ড্ৰাইভত আছে সেইটো পুলিচে জব্দ কৰিছে
The seizure list also says that, Lordship, only the pen drive. One
Ah.
ScanDisk 60 GB pen drive containing videography recorded by Oliul Islam. and
Now, I
Vice
don't know,
Chancellor of
I
the-
have not operated any camera, but whether it is always in the pen drive it is recorded? I don't know, I have not operated any video camera. So whether it has a original memory, the camera, or it is always stored in the pen drive.
No, it is in this, Lordship, it is in the camera,
Differ
but
from-
then by fitting in the hard, this card, memory card, that has to be converted in the computer and then it can be taken away in a pen drive. Detachable form.
Where is the seizure list?
Page 37, Lordship. That bunch, minor.
That second last page,
Last
Lordship,
bun-
of this
bunch.
Xerox copy page, Lord. There were 207 papers.
Xerox copy.
The second last page, Lordship.
Second last page.
Lordship, seizure list.
Seizure list. Ejur Sosma.
Yes, Tosma, before that, Lordship.
Before that,
If it is transferred,
Lordship.
if it is transferred, okay, no, otherwise, mister.
Yes,
If it
yes,
is original recording, then thereafter it is transferred, then it is secondary evidence.
No.
If it is transferred in the pen drive
Lordship.
from the memory
That is a
slot of the
different matter.
camera of the Sony HDR,
Yes, ma'am.
then it is secondary evidence.
Yeah.
Otherwise, from the statements of the witnesses, there is nothing.
Regarding their names.
They will identify
Yes,
the witnesses
Lordship.
for the first time in the witness box.
Lordship. Lordship.
And that is,
Because for, in this type of cases, my lord, their names cannot be given.
what?
My lord,
But
the
the
witnesses.
the other evidence also,
Witnesses accompanying the, my lord.
you are seeking quashing.
Lordship.
Yes.
So other evidence also,
Other evidence in my humble submission, so far as my lord, MLA is concerned, my lord, that is very pinpoint, my lord. Their name, his name has been uttered, my lord.
we'll obtain the
And-
scanned copy of the
Yes.
case record, but in the meantime, there is nothing,
But my lord,
finally.
against all or against?
No.
These petitioners, MLA will remain,
Yes, yes.
MLA is-
MLA will remain.
Yes.
There is ample evidence,
Ample evidence, my lord.
Coming for MLA.
Yes.
ample evidence
Ample
against him.
evidence, my lord. And against them.
MLA is not part of this petition.
Yes, oh, sorry, man. I am,
We'll observe.
yeah.
7 except identifying this
Yes.
so that he shall not come at a future date,
My
showing that similar order is to be passed.
similar, my lord.
No.
But so far, my lord, as a, for the interest of justice, so far, my lord, the witnesses are concerned, my lord. They have stated several.
Yes,
persons-
IO has done it.
Yes.
IO
and
should
the-
have,
And also your lordship will find, my lord. Currently, the
because
resources,
even if they got anticipatory bail,
they are in,
they could have, IO could have obtained their photographs also.
yes, that, we are not aware whether it is there or not. my
Not
lord.
there.
Yes,
You can examine the search sheet, Mr. Gusami.
yes, my lord.
What have been seized, what not have been seized.
Yes, it is there, my lord.
Just for the sake of objecting, should
No,
not
no.
object.
No, I am not saying.
The objection should have been made on rational ground.
Yes, my lord. So far,
There is nothing.
Yes.
I have given ample time.
Yes.
I have heard you.
yes, my lord.
I
Photographs
have
were-
examined.
Yes,
Nothing is part of the record.
Yes,
What
the-
is there already mentioned? Please see. I have seen already.
yes, yes.
I have seen already. Just for the sake of objection,
No, my lord. I am not. saying
don't
that, my lord.
object.
Not saying that.
If it is really there is a
Yes.
rational ground, then definitely
No, see.
see the list of documents.
No, see. For page 45, Lordship.
Page 45.
Lordship.
Sketch map of the PO,
Lordship.
seizure list, 7 number of bail bonds, 1 medical injury report.
Easy report.
And medical injury is clearly relatable to the MLA,
Yes, yes, that,
right?
yes,
Sketch map of the PO,
yes,
seizure list, 1 bhanga sosma and the pen drive.
pain that,
And pen drive, if it is separate,
yes,
if the Sony HDR
lots,
is separate memory slot and wherefrom
Mm.
this pen drive is prepared, then it is secondary evidence.
yes.
If
it
the
is-
whole
if
thing
it-
is submitted and
Yes.
seized,
This is it cannot be certain whether it is seized or
you
not.
make up your submission.
Yeah.
I am suspending
That's-
the
Hello.
trial so far as the petitioner is concerned.
Lots,
But if you come up with,
lots,
then we'll recall the suspension order.
lots. Page 33, your Lordship may see, my lord, just why it is not done, my lord.
Why it
Yeah.
is?
Currently, the resources and examination tools are not available for examination of video files.
What to do if your
that-
government of India
that
does
is-
not have the facility
That is what it is written, my lord.
in the era of Brahmos? What
No.
can we do?
It is in the, my lord.
We are helpless.
19, my lord.
In the era of Brahmos,
Yes.
if you can't examine a pen drive,
Why
what can we do? Heart, Mr.
2019, my lord.
S.K. Puddar, learned
Yes.
counsel for the petitioners. And MP Goswami, learned additional public prosecutor for the respondent number 1, state of Assam. Post of 7 number of the petitioners, 7 in number. Have joined together to institute the instant criminal petition under section 528 BNSS, seeking setting aside of and quashing of the criminal proceedings of PRC case number 105 2024, within which arose out of Kazigaon Police Station case number 35 stroke 2018 and GR case number 431 stroke 2018, and presently pending before the Court of Learned Additional Chief Judicial Magistrate, Kamrup,
Kokrajhar.
Kokrajhar. Post of para. The primary contention of the petitioners are that in the FIR lodged on 22/5/2018, they were not named. Post of. In the course of investigation, the FIR was lodged in connection with an incident of alleged assault on one what is the full name?
Momila Ravidas.
Momila Ravidas, the then Block Development Officer, Devi Tola Development Block, by the then MLA of Gauripur, LAC, what is his name? Nizanur
Rahman.
Mohammed Nizanur Rahman,
Rahman, my lord.
and 15 of his accomplices on 22/5/2018, when there was a visit to Nobokumar Dong near Kajigaon. Post of. The FIR was registered for the offences under section 147, 341, 352, 353, 323, 427, 506, IPC on 23/5/2018. Full stop. During the course of investigation, statements of number of witnesses, statement of number of eyewitnesses were recorded under section 164 CRPC, and seizures seizure of a pen drive which stated to have recorded the incident of assault was also seized. Full stop. After conclusion, on conclusion of investigation, a charge sheet under section 173(2) CRPC by charge sheet number 72/2023 was laid on 29/11/2023, wherein how many?
Total seven.
Eight. Eight number of persons, including the present petitioners. No, eight number of persons comprising of the then MLA, so and so, LAC, and the present petitioners have been charged. Full stop. After certain proceedings, before the Court of Additional Judicial Magistrate Kokrajhar and the Court of Learned Session Judge Kokrajhar, charge yes against the 8 accused persons were framed for the offenses under section 147, 341, 353, 323, 506 IPC. After finding no materials to fulfill the ingredients of section 3 within bracket R within bracket S within bracket U of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989. Full stop. The trial of the case is presently at the stage of evidence. Full
Yes.
stop. At the stage of
Evidence, man.
Evidence.
Full stop. Para. The statements, Mr. Poddar and counsel for the petitioners has relied on the statements of the witnesses recorded under section 161 CRPC to submit that none of the witnesses listed in the charges had named the present petitioners. Full stop. The only other evidence, according to Mr. Poddar, is a pen drive which allegedly recorded the incident of assault. Full stop. Even such pen drive, even the said pen drive is also without the the pen drive, which can only be secondary evidence, is without any certification. In such view of the matter, allowing the trial to proceed without any privacy material will be an abuse of the process of the court. Mr. Goswami, in addition, public prosecutor has, however, vehemently contested, has vehemently objected by submitting that, has vehemently objected to a contentions raised by submitting that the witnesses were present at the place of occurrence, and there would be identification of the accused persons during the testimony before the court. Post of the matter would require further consideration, issue notice returnable in 4 weeks. Having regard to the materials sought to be laid by the prosecution in order to bring home the charges framed against the petitioner. This court is of prima facie view that the petitioners have made out a case for interim relief. So it is accordingly ordered in the interim that the proceedings of so-and-so case number presently pending before the court of so-and-so shall remain suspended till the returnable date. তার আগতে লিখিব scan copies of case records of so-and-so be called for.
Yes, my lord, once again, maybe my lord, I stand corrected, my lord. Lordship, FIR, my lord, final report has been submitted on 2018, my lord. That is after just after that certificate, non-acceptance of the certificate has come out. Now, at this point of time, my lord, perhaps whether a report might have been there in the scan, my lord, the scan copy of the record.
Produce.
My lord,
Write letter.
yes, my lord. If
You
scan,
verify from the IO.
yes, my if scan copy is called for, my lord,
The
that
trial will prolong for 5 years.
scan copy if called for, my lord, that your lordship.
Scan copy.
And
I
then, my
called
lord, that is one point, my lord. Perhaps FSL might be there at this point of time, 2018, my lord, 2025, my lord. In between, it can be submitted.
Show me, I'll recall the.
Yes, my lord. Yes, my lord. One part, my lord. And
I am open to everything.
Yes, yes, my lord. And second part,
I'm
my lord.
framed in my mind.
No. Just I am expressing my mind subject to cards.
If FSL is available, if you have, it was a par search
Yes,
sheet, FSL, yes, it is
yes.
permissible, Mr. That cannot be challenged. I am quite
Lordship.
100% sure that some thing can be made pending FSL report.
FSL.
That is permissible, right?
Yes.
That contention does not make any
No,
ground.
submission of further investigation.
Yes. FSL, awaiting FSL report, search sheet can be submitted in
Yes,
part.
it is
That
not-
is permissible and that is law.
This charge sheet is of 23 lots.
Whatever.
My friend saying,
Now,
but it is of 23.
If you have got, if you have during the course of further investigation, if you have seized the
Yes,
Sony DVR, you place it.
Lordship.
I'll definitely recall the order.
Yes, requesting for stay of the further proceeding.
Suspension, I have
Yes.
seen.
And another aspect, my lord, my lord,
May I-
regarding the other ground, my lord, which my learned senior friend perhaps has not taken regarding cognizance of STS. My lord.
No, he has not
Yes,
taken.
yes. Because
It is
if it
additional.
comes, my lord, again.
No,
the
if
order-
that starts, then there is a different issue.
Order will be completely different.
No, I
my
have been asking, that is
Yes,
why
but if-
repeatedly.
lord. At later-
I'll record. Mr.
later stage-
Poddar has not, however,
Yes.
has submitted that he is not raising any ground as regards the taking of cognizance by the learned so-and-so in the matter of offences related to SC/ST so-and-so atrocities act.
Lord, may I request for a copy of the order because tomorrow case is fixed, Lordship, but before the trial court.
You can say that court has passed suspended.
I have been preparing on that line, my lord.
Lordship. Obliged.
I am obliged.
Not like to take on an earlier
Oh.
occasion, or she
Okay.
did not. But at the same time, my lord, there is some urgency because before the trial court, next date fixed is to 2nd.
Okay.
So my lord, after tomorrow, let it be.
Release the
The
case.
thing is, my lord, the registry will have to take up the matter.
Before any other events, without me, before events without me, Mr. Kenchuri, Learned Senior Counsel, preparing for a petitioner, has expressed urgency in the matter and has sought listing of the case on today is
Today is
Tuesday,
29, my lord.
29 of 1st of August,
31st.
29 or 29, 31st.
31st.
31st is there.
Thursday.
31st, okay. Registry to take necessary steps for listing.
If-
Say listing. Yes.
My lord, this petition is filed under 528 of the PNSS, my lord. What happened, my lord? The petitioners herein are the accused, my lord, under section 379, my lord. And my lord, what happened, my lord? Before COVID-19, my lord, 6320, they had appeared before the learned trial court, my lord, and they were allowed to remain on previous bail, my lord.
2012
Thereafter, my lord,
FIR.
due to COVID-19, my lord, they could not-
2012 FIR.
my lord, page number 11.
Page number 11.
Yes, my lord.
Then charge sheet 2014.
Charge sheet. Yes, my lord.
Yes, then thereafter.
Then
what
they
happened?
appeared, my lord, on 6320, my lord, page
Hmm?
number 32, my lord, and they were allowed to remain on previous bail, page number 32, my lord.
32.
Yes, my lord.
Yes, thereafter.
Then, my lord, due to COVID-19, my lord, page number 34, my lord, page number 34, from 7/4/20 to December 20, my lord, due to COVID-19, court was not functioning, my lord. And my lord, page number 34, your lordship will find order dated 19/3/21, my lord, page number 34. 19/3/31, my last order, my lord. They were appeared through their engaged counsel, my lord. They are represented, my lord. During the COVID period, also 21, my lord. Then, my lord, again due to COVID, my lord, the court were not functioning, my lord. And then page number 35, my lord. They were again represented by the engaged counsel, my lord. Page number 35, 3/11/21, my lord. 3/11/21 order, my lord. Then, my lord, again 21/22 due to COVID, my lord, the case was fixed for, my lord, copy and charge, my lord. And again, they could not appear, my lord. Page number 35, 21/22, my lord. Then, my lord, page number 40, next date 21/2/22, my lord. Page number 40, my lord. From that date, my lord, they could not appear, my lord. They were, my lord, daily wage laborer, my lord. And after the COVID-19, my lord, for earning their livelihood, my lord, I have, my lord, fairly admitted in my, my lord, petition, my lord, page number 6, that they had to, my lord, earn their livelihood. They had to, my lord, leave the state, and they, my lord, in the state of Kerala, they, my lord, went there, my lord. And now, my lord, they on return, my lord, they came to know that NBWA issued against them, my lord. They are ready to face the trial, my lord. Only
Yeah,
1 week
Mr.
time may be given, my lord.
Lordship may kindly say, my lord, incident of 2012, my lord. 2014 searches submitted, my lord. And my lord,
So
2017,
each
my
and
lord,
every date without fail.
Yes, my lord.
2017, my lord, cognizance taken. After that, my lord, they have not appeared, my lord. Again, my lord, non-bailable warrant was issued, my lord, but they have appeared, my lord. So trial court, my lord, allowed them to remain on previous bail, my lord. After that, they have again started not appearing, my lord.
Due to COVID, my lord, and the engaged counsel represented, my lord. Now, my lord, within 1 week, my lord, we are ready to appear, my lord, and face the trial without fail, my lord, any date, my lord, without failing, my lord. Within 1 week, we will appear, my lord. We will
Let
face
them,
the
my lord,
trial.
otherwise it is already 10 years gone, my lord.
So undertaking is on each and every date of the
Yes,
trial.
my lord. Yes, my lord.
Third, Mr. M.J. Kwadil, Learned Counsel for the petitioners. And Mr. R.J. Borua, Learned Additional Public Prosecutor for the respondent state. Pustak, the instant criminal petition. Under section 528, Bharatiya Nagarik Surakha Honita 2023 is preferred for quashing of the orders, comma, dated 21/2/2022 and all subsequent orders whereby non-bailable warrants of arrest were issued have been issued against the petitioner in order to secure their appearance in the trial of ZR case number 5002/2012, which is presently pending before the Court of Learned Judicial Magistrate First Class Kamrup Metro at Guwahati. Post of the FIR, First Information Report, in connection with Khetri Police Station case number 67 of 2012 was registered on 17/5/2012 for the offense under section 379 IPC. Post of in the charge sheet submitted after conclusion of investigation by charge sheet number 78/2014 on 31/8/2022, both the petitioners were charge sheeted. Post of on submission of the charge sheet, process was issued to the petitioners to appear in the trial. Post of before the Court of Learned Judicial Magistrate First Class Kamrup Guwahati, the petitioners appeared on 6/3/2020 with a prayer to allow them to remain on their previous bail. Post of the learned magistrate allowed the said prayer of the petitioner to remain on previous bail with a direction to remain present and not to make default in their appearance before the court. Post of in view of onset of COVID-19 pandemic during the year 2020, the court proceedings were adjourned. Post of and the trial did not proceed further. Post of it was on the accused, the petitioners as the accused persons were sporadically present during the continuance of COVID-19 pandemic. Post of it was on 21/2/2022, the learned court finding the petitioners absence without any steps, issued non-violable warrant of arrest against them to secure their appearance in the trial. Post of petitioners in this petition have averred that
Paragraph 9, my lord. Page 6 and 7.
facing financial difficulties after the COVID-19 pandemic, they had gone to Kerala for their livelihood as they are laborers by occupation. Full stop. The petitions have further averred that recently they have returned from Kerala recently and they came to know about the fact of issuance of non-bailable warrants of arrest, provide orders dated page 70 not আছে অৰ্ডাৰ কেইটা পেৰা 6ত আছে অৰ্ডাৰ ডেট কেইটা পোষ্ট অফ পেৰা মিষ্টাৰ Query Learning Council Board of Petitions has submitted that the petitioners are ready and willing to participate in the trial henceforth without any default, and they would be present on each and every date of the trial pertaining to GR case number so and so. Full stop. Para Mr. Borwal and additional public prosecutor appearing for the respondent state has submitted that the trial has become protracted due to repeated failure on the part of the petitioners to appear before the learned trial court. Post up. The incident is of the year 2012, and as such, an expeditious conclusion of the trial is of utmost importance. Full stop. Para. As the petitioners are giving an undertaking that they are ready and willing to participate in the trial of GR case number so and so, and they would be present in the trial on each and every date without any default. This court is of the considered view that in the interest of expeditious conclusion of the trial, an opportunity can be granted to the petitioners to appear before the learned trial court within a period of 2 weeks from today. Full stop. Allowing the prayer of the petitioner, it is ordered that the non-bailable warrants of arrest issued against the petitioner void order dated 2022 and thereafter shall remain suspended for a period of 2 weeks. Full stop. The petitioner shall appear before the learned trial court within a period of 2 weeks, and if the petitioner submit an application for bail upon such appearance, the learned trial court shall consider such bail application in accordance with law and its own merits. Full stop. It is further observed that in the event of failure on the part of the petitioner to appear before the learned trial court within a period of 2 weeks from today, the warrants of arrest issued against the petitioner shall stand revived. Full stop. With the observations made and direction given above, the criminal petition is disposed of, no cost.
Highly obliged.
Item 7.
May I please? This petition is filed for quashing of the FIR, the sheet and the proceeding of the trial court lordship. In fact, lordship, this matter is relating to matrimonial dispute. And this is the third case caused by the wife against the husband and her father-in-law, mother-in-law, brother and sister-in-law. And some others were also incorporated, but their name has not been sent to for that fire. And the name of husband, father-in-law, mother-in-law.
Who are the petitioners here?
My lord, here 5 petitioners.
Petitioner number 1 is who?
Petitioner number 1 is the husband. two is the mother-in-law, and 3 is father-in-law. 4th is sister-in-law, and 5 is the brother.
Allegation, FIR.
My lord, FIR lordship, your lordship will find at page 17, start from 14. And in fact,
17.
long complaint that was filed before the under trial court, which was forwarded to the police station, subsequently lordship PS register. The lordship kindly come to page 19. Just to
What is the offense alleged?
Alleged lordship, section 85, that is lordship equivalent to 498A. And 82, 1, 83, 316.
Hey, Gerard, quick.
My lord, this is relating to marriage.
Quick, Gerard's pretty good.
My lord, this two section 82 and 83 relating to marriage during the
Relating to?
relating to marriage during the subsistence of first marriage, earlier marriage. And 316, this is criminal.
Let us see the search sheet.
Hello. Charge sheet.
Yes.
That is page 25, and relevant your lordship will find page 34. Tax disclosed during the course of inquiry.
So petition number 1 entered into second marriage
Yes, and the
without,
wife is also entered into marriage after lodging this.
no, you committed the one first. You committed the marriage first.
Yes, first I.
Then
because
it can be a tit for tat, but that does not mean that
he voluntarily-
you are the first offender.
he
You were the first one who entered into marriage.
My lord, I had no option because.
No option is different thing.
Various steps.
No, without being divorced, how can you?
And she has already entered into marriage.
That is subsequent.
Same thing.
If you shoot a person and in defense, the other shoots you, you are the first offender.
That is their lordship.
If you are clean, then you allege others. If you yourself is not clean, don't throw mud
In
to
fact,
others.
this is I married her, she is the second time lordship, I entered into marriage with me. Earlier, she was married with another person. He left her after 6 months.
Yes, Mr. Boro.
Within 6 months of marriage, my lord, he was forced to leave the matrimonial house. And my lord, this is the.
What are the allegations against the in-laws?
In-laws lordship only that instigation. Instigation in the name of demanding dowry and.
Page number 6, my lord.
We'll obtain the scan copies, then we'll see.
These are
What
matter
are the
of trial, my
statements?
lord. These are the matter of trial, my lord. At this stage, my lord, let the notice issue, my lord, let her appear.
We'll issue notice, we'll get the scan copies. Then we'll examine.
Till then lordship, further proceeding may be step.
No, absolutely not. Otherwise, I'll decline. If you press for interim order,
Yes.
we'll pass the order. You make your submission on interim prayer.
So
I do not change my stand later on. Yes.
lordship is saying so lordship.
No, we'll keep it open, but without anything, without the statements of the witnesses, it is very difficult.
My lord, in the charge sheet lordship, the police has already stated.
What is the parameters for quashing?
This is only.
Can we attain that satisfaction on reading the FIR? Tell me, that's all.
But as far.
Remember Bhajan Lal
Yes.
and make submission on the basis of the FIR
My lord, subsequently. lordship,
for staying. Quashing is another thing.
Yes.
Quashing after detailed hearing. right? Whether a primacy case is made out or not made out on the FIR,
My humble submission, no case has been made out.
Okay,
let
let us
uh,
read then. Let us read the long. You are an officer of the court, so let us read it
Your Lordship,
together.
implied.
Let us read it together. You are an officer of the court also. Let us read it. Who are named? And this may entail also dismissal at the motion also. I am making it clear. Abdul Rakib.
Then your Lordship may issue notice and a Lordship short date may be given after receiving LCR Lordship interim may be considered.
That is why I proposed at first itself.
My Lordship, I
Because
made some submission.
if the ingredients of the offense are there,
Otherwise, Lordship,
and we can also examine if the materials are not available. There are many situations may arise. Yes, ingredients may be available against the husband, may not be available against the in-laws.
all
But that
available.
can be arrived at after seeing the statements, right? Because IO will say everything a privacy case is made out, sufficient materials. FIR discloses that. We'll issue notice at this stage. We'll keep the interim prayer open for consideration after receipt of the scanned copies of the case record. I think that is the most reasonable one. Heard Mr. M. Khan, learned counsel for the petitioners, and Mr. R.J. Borwal, learned additional public prosecutor for the respondent state. Post of the petitioners, 5 in number, have joined together in the instant criminal petition seeking quashing of the proceedings of which case?
Lordship, PRC case number.
PRC case number
46, 2020.
246, 2025, which is presently pending before the Court of Learned Subdivisional Judicial Magistrate S. Kokrajar.
SDJMS.
S. Hodor.
Sorry.
Subdivisional Judicial Magistrate Hodor, S. Kokrajar. Petition has also sought for quashing of an order. Where is that order?
My lord, order is at page 36.
36.
Taking cognizance.
Order dated 19/6/2025. Taking cognizance of the offenses under section 85 within bracket stroke 316 within bracket 2, comma BNS. Full stop. The petition number 1 is the husband of the informant, whereas the petition number 2 and the petition number 3 are the mother-in-law and the father-in-law of the informant. Full stop. The petition number 4 is the sister-in-law. And the petition number 4 is the brother-in-law of the informant. Full stop. Mr. Khan, learned counsel for the petitioner, submitted that all are living together.
They are separate, living separate.
Okay. There are no allegations against the petition number 4 to 5. Full stop. He has further submitted that the petitioner, the informant, has subsequently entered into marital relationship with another person. Post of para, Mr. Borwal, an additional public prosecutor, has pointed out that it is the petitioner 1 who has entered into marriage with another lady prior to the informant's prior to the informant. Full stop. The matter can be considered. The issues can be considered after examination of the case records of PRC case number so and so. Issue notice returnable in 3 weeks. The petitioner shall take steps for service of notice upon the respondent number 2. R.J. Borua, respondent number 1. By registered post with AD as well as by usual process, the prayer for interim relief is left for consideration after receipt of the TCR, scanned copies of the TCR. Yes.
May I please, your lordship, this petition is filed against the order dated 22/4/25 passed by the Learned Judicial
Which
Magistrate.
page?
Page. Annexer 1, page number 11.
Page number 11.
Yes, Your Honor. Your Honor, the case was fixed on the date for filing DW evidence, but the DW evidence was ready, but the learned counsel could not appear before the court on that day due to the water lodging in front of her house and at her locality. Page
22/5/2025.
22/4.
4.
22/4/2025.
Repeated adjournment. Since when the stage was for DW evidence?
From January. February, March.
January. How many adjournments you sought?
3 adjournment earlier. Your Honor, the petitioner, the present petitioner was suffering from mental disorder since 2022.
When the case was fixed for DW
The case was
for the first occasion?
January, 3rd January 2025.
Can we get it from your bulky petition?
Orders. Your Honor, page number 156.
1.
56.
When the prosecution evidence was closed?
Prosecution evidence was closed on 22/4/2025. Page number 11.
No, prosecution evidence.
DW. PW evidence was closed on
Yes. When?
7/11/2024.
Who is cross-examined? Page
155. Your Honor,
7/11 it is closed.
yes, Your Honor.
So
The
you are
case-
defaulting on many counts. Payment of arrears.
Yes, Your Honor, the arrear is pending due to the lockdown situation 2020 and 2021.
2025.
Your
2025.
Your Honor, the petitioner is an unemployed person, and Your Honor, most important fact is that the present respondent could not allege that she was married with the present petitioner, but she could not
7.
produce any single documents of her alleged marriage. She bring the allegation.
Oh, we are not appreciating the evidence, madam. It is for the court to appreciate the evidence.
Your Honor, we are going for appeal against the maintenance order passed by the Learned Judicial Magistrate on TV case. Lordship, the present petitioner is an mentally sick person, and the medical documents is annexed herewith. Annexer.
What is your petition on 22/4/2025?
Your Honor, the petition is filed,
Who is that?
the, no, Your Honor, the petitioner is not, next year.
Oh, did you disclose those?
Yes, and the DV,
Do you have the copy?
22 for petition,
Because, see, madam, due to failure on the part of the respondent to adduce defense evidence for 4 occasions, DW has been closed, right?
Lordship, yes, Lord.
And if there is no reason assigned for granting further date for DW, then this order seems to be perfectly correct, right?
But Your Lordship, we have filed a petition by my junior, but there is a misunderstanding between C and me. C not try, not. Please.
Madam, when an order can be set aside, when it is something wrong, there is something wrong. What is, if you're in your petition, what did you disclose?
Your Honor, Lordship, disclosed that the representing advocate could not file the DW today as there is a water lodging in her locality. And Your Lordship, the paper cutting is annexed here.
Paper cutting is okay, but what was the petition? And what you were saying, that mentally ill or something like that?
Yes, Your Lordship, on the page number, annexure 7, page number 75 to 86. The present petition, due to his mental illness, he could not appear before.
No, is there any certificate? This, I don't know the medicines. I cannot understand the meaning of medicines, right? I don't know for what ailment these medicines are prescribed. Is there any certificate?
Yes, Lordship,
Where is that?
the certificate is not annexed here with.
Because I cannot derive an opinion from these prescriptions. I'm not a medical expert. What this Zolkel, I cannot read the name of the medicine also.
Yes, Lordship.
Do you have anything to substantiate that he was suffering from something which has prevented him to adduce evidence? These are of 2024 only, up to July.
2022 onwards.
2022 to up to July 2024. Some medicines are prescribed without saying anything further. We don't know for what reason the medicines are prescribed.
Your
You have not annexed the petition also. And what wrong?
Your Lordship.
This order, there is no further adjournment, because I have seen many times since November, 3rd of January 2025.
Yes, Lordship. But the
One,
evidence
two,
is
three,
that on that day, Your
4 occasions.
Lordship, by counting the 22 for 25, this is the 4th day. If you-
Yes.
and
How
Lordship,
much adjournment?
On that day,
CPC allows how much?
Lordship,
You are beyond 3.
Lordship, on that day, the evidence was ready, but due to the learned counsels, the petitioner could not file the DW evidence. And if the DW is not filed, the petitioner will suffer
Yes.
irreparable loss.
Default is on your part, madam. There is no wrong with the order. DB case. Yes.
But apparently there is no wrong, my lord, from since.
No wrong.
No, since January, my lord, to April.
Can,
Adjournment.
but you have made the agreed person wait for 4 occasions.
Yes, Lordship, but on the agreement.
You pay 5,000 cost. One last opportunity. Hard. Miss
Arcolita.
R. Colita, Learned Counsel for the petitioner. and Mr. B. Sharma, learned additional public prosecutor for the respondent number 2 state of Assam, poster. The petitioner has sought to invoke the inherent powers of this court available under section 528, Bharatiya Nagorik Suraksha Sanhita 2023 to assail an order dated 22/4/2025, passed in DV case number But what is the stage at present?
Fixed for argument.
When is the next date?
Today is the date of next day.
It
Today,
is adjourned or closed? What prayer you have made?
today the case is fixed for argument, first date argument.
In DV case number 37/2017, presently pending before the Court of Learned Judicial Magistrate First Class Kamrup Metro at Guwahati, within bracket trial court for short. Full stop. Para. The proceedings of DV case number 37/2017 got initiated at the instance of the respondent number 1 as the aggrieved person. Also, para. Having regard to the issue involved, by the order dated 22/4/2025, the learned trial court has declined to grant any further adjournment to the respondent number 1, that is the petitioner hearing, and he has been debarred from filing evidence. Full stop. In having regard to the issue involved, raised in this criminal petition, the criminal petition is taken up for consideration. For final consideration at the motion stage itself, dispensing with the process of issuance of any notice to the respondent number 1 hearing, that is the aggrieved person, in DV case number 37/2017. Full stop. Para. From the materials made available with the criminal petition, it has emerged that the aggrieved person had reduced evidence of 4 witnesses, and it was on 7/11/2024, the evidence from the aggrieved person's side was closed on that day with the examination, cross-examination and discharge of PW4. Full stop. On 7/4/2024, the aggrieved person verbally submitted before the trial court that she had no more witnesses to adduce. Full stop. The learned trial court had thereafter posted the case on 3/1/2025 inter alia for defense evidence. Full stop. On the subsequent dates of listing, comma, 3/1/2025, comma, 4/2/2025, and 18/3/2025, comma, the petitioner as the respondent number 1 did not adduce any evidence in his support, and on those occasions, comma, he had sought adjournment to adduce evidence. Full stop. Para. When the case was posted on 22/4/2025, comma, the respondent number 1 was found absent with steps, whereas the aggrieved person was in attendance. Full stop. The petition, comma, petition number 1017/2025 was filed on behalf of the respondent number 1 seeking adjournment. Full stop. It is relevant to mention that distress warrants were already issued against the respondent number 1 due to his failure to deposit area maintenance amount.
Remain 19,000 area.
Deposit. What do you say in DP case? Maintenance or what?
Interim maintenance.
Interim maintenance amounts, which had fallen in arrears. Full stop. The Learned Trial Court observed that the respondent number 1 had failed to adduce any evidence in defense despite taking repeated adjournments. With such observation, comma, the trial court has decided not to allow any further adjournment and has debarred the respondent's side from filing any DW evidence. Full stop. It is in the said facts and circumstances, comma, the instant criminal petition is preferred. Full stop. Ms. So-and-so, learned counsel appearing for the petitioner, has submitted that on 22/4/2024, comma, there was torrential rain. As a result, comma, there was waterlogging in the entire city. Full stop. To submit to support such submissions, comma, and the petitioner has annexed newspaper reports. Full stop. It is further submitted that during the period from 2000, the petitioner has been suffering from mental ailments and he has been prescribed meditation by doctors. Most of the prescriptions are found annexed. Medical prescriptions are found annexed from page number 75. To 86 of the case papers. Full stop. There is, however, no certificate to support the fact that the petitioner is suffering from mental ailments. Full stop. Para. As the aggrieved person side has adduced evidence through 4 witnesses and as not like full stop. On the earlier 3 occasions, the Learned Trial Court granted time to the petitioner to adduce evidence in his support after having been satisfied with the regions assigned for granting time. Full stop. The Learned Trial Court in its order dated 22/4/2025 has not assigned any region for rejecting petition number 1017/2025, through which the petitioner prayed for an adjournment. Full stop. The order dated 22/4/2025 does not reflect that petition number so and so has been rejected. Full stop. As the petitioner has averred that he has material facts to depose from this court, he is of the considered view that in the interest of justice, one last opportunity can be granted to the petitioner to reduce his evidence. Full stop. Subject to payment of costs to the aggrieved person as due to adjournments at his behest since 3/1/2025. The aggrieved person has been made to wait. Full stop. Having regard to the above considerations, this criminal petition is allowed by granting one last opportunity to the petitioner, who is a respondent number 1 in DB case number so and so, to adduce his evidence subject to payment of a cost of rupees 5,000. Subject to deposit of a cost of rupees 5,000 before the Learned Trial Court. Full stop. The petitioner shall adduce defense evidence on the next date of posting of DB case number 37/2017 with a deposit of rupees 5,000 before the Learned Trial Court. It is further observed that the sum of rupees 5,000 to be deposited by the petitioner is to be dispersed to the aggrieved person. Full stop. The criminal petition is allowed to the extent indicated above. It is further observed that in the event of failure to adduce defense evidence by the petitioner on the next date of posting, there it is the opportunity, no further opportunity, is to be, shall be granted by the learned trial court to the petitioner.
May I please, Your Lordship?
Custody.
May I please, Your Lordship? My lord, this petition is relating to Jimma of the seized battle nuts, Lordship. Lordship, the facts of the case, Lordship.
Where is the impugned order?
Lordship, the original impugned order, Lordship.
Where is the last impugned order?
Yes,
What
Lordship.
you have challenged?
Yes, Lordship. Last order.
What you have
that
challenged?
Starts from page 16, Lordship.
Impugned judgment, 3/7/2025. What is that?
Yes, Lordship. 3/7/2025.
This is for?
This is, Lordship, by which, Lordship, my revision petition was dismissed, Lordship.
Dismissed for what? Custody of seized battle nut.
A custodial system.
Seized battle nut.
Seized battle. Lordship, the.
Will issue notice.
Lordship, Lordship, because there is a auction
At
order.
least there is nothing.
My lord, there is a auction order, Lordship.
Auction order.
Yes, Lordship.
Which order?
Lordship, 1611, Lordship, at page 49, Lordship.
Page 49.
Yes, Lordship. That is a auction order passed by the learned additional CJM, Lordship.
Additional CJM.
Set aside.
Hmm?
Lordship, if I may be allowed to.
16/11/2024.
Yes, Lordship.
Okay, it was an auction order.
Auction order.
Okay.
That set aside by the learned court, session judge, Lordship.
Session just
Yes,
set
Lordship.
aside. Then
In the judgment dated 18/1 at page 52, Lordship. That revision. That was set aside and allowed me to file a fresh petition.
File it.
Yes, I have filed, Lordship. Then, Lordship, what was the observation of the learned additional CJM, Lordship? Page 59, Lordship. Page 59, without observing any observations of the learned session judge, Lordship, the learned additional CJM straightly saying that as
No, no.
already the
Firstly, what is this page 49?
page
please tell me.
49 is the last order of the additional CJM holding that
And what is this order? Page 52.
page 52 is the revision order passed by the learned session judge. Your Lordship,
So this page 49 order was prior to page 52 judgment.
yes, Lordship.
Then,
Prior to page 52 judgment.
yes. This 52 judgment is 18/1/2025.
Yes, Lordship.
And thereafter, any proceeding?
Yes, Lordship. Then
Which proceeding?
again, as per direction, again I approach the additional CJM. Then
Where is the
59
direction?
order.
Where is the direction?
Lordship, that Lordship, your Lordship may kindly page 57, Lordship. Page 57, paragraph 15. At this stage, it is directed that fresh order will be passed after considering those documents placed with the custody petition. It is observed that learned court of the additional CJM Hailakandi will not be guided by this order.
Let us see, it is directed phrase or I have carefully considered all grounds mentioned. While passing the impugned order, ought to have considered the place where it had done. The cause prejudice. It is open to visit or accept nickname and matters must be considered repaired and nothing has been discussed about those documents specifically discussed is maybe in advance of crisis cases. Okay, this.
That 1611 goes, Lordship. That 16/11/2024 order by which auction was issued, that was already set aside. Then, as per Lordship, I approached again the additional CJM, page 59 order. Page 59 order, 15/2/2025, Lord. Saying that Jimma prayer is infraction.
Yes, Mr. Sharma.
My lord.
Come to page, let us one by one. Come to page 49. Page 49.
49.
16/11/2024,
My lord.
correct?
My lord. 1611.
Page 51. Direction for auction. Direction for auction. Last, keeping in view of the above, the prayer of investigating officer is allowed subject to the condition auction is done according to the proper procedure of auction, right?
My lord.
Then this criminal revision petition. Page 52. Session judge,
My lord.
right?
My lord.
Now see page
57 is the one.
57, paragraph 16.
15.
16. Read? Have you read? Now come to page 59.
59.
By the order, it is 16/11/2024. Heard, Mr.
NH Board.
NH Borbhia, Learned Counsel for the petition. And Mr. B. Sharma, Learned Additional Public Prosecutor for the respondent number 1, State of Assam. Full stop. The subject matter of this criminal petition under section 42528 BNSS is pertains to interim custody of 8850 cases of seized areca nut contained in 177 gunny bags weighing 50 kg each. Full stop. The said quantity of areca nuts was seized in connection with Algapur Police Station case number 197/2023. Full stop. Para. The learned Court of Additional Chief Judicial Magistrate Hailakandi by an order dated 16/11/2024 allowed a prayer of the investigating officer to hold auction of the seized areca nut as per proper procedure. Full stop. Assailing the said order dated 16/11/2024, the petitioner preferred a criminal revision petition, registered and numbered as criminal revision case number 82-2024 before the Court of Learned Session Judge Hailakandi. Post by judgment dated 18/1/2025, the Learned Session Judge Hailakandi allowed the revision petition by setting aside the order dated 16/11/2024 passed by the Learned Additional Chief Judicial Magistrate Hailakandi. Full stop. It was further directed to the Learned Additional CGM Hailakandi to pass a fresh order after considering the documents placed with the custody petition of the petition. Full stop. Para. The Learned Additional CGM Hailakandi subsequently disposed of the interim custody petition as by rejecting it and by holding it as infractious with the following observations. Page 59. Pencil to pencil. Then what happened? Page 60.
Then Lordship, I again approached the Learned Session Judge about, but this time Lordship Learned Session Judge rejected my revision, saying that there are no grounds at all.
When a revision,
That revision,
when a revision petition was again preferred against the order dated 15/2/2025, thus, which was registered as criminal revision case number 5 of 2025, the learned session judge, by its judgment dated 3/7/2025, dismissed the same. Yes, what is this going on?
Yes, my lord. My
What
lord,
is this going on?
para my lord 8 and 14. And again, my lord, that order, my lord, that allowing that, my lord, 16/11/24, that order, my lord.
Firstly, I am perplexed. When the revisional court has set aside the order,
My lord,
right?
my lord,
It is out of existence.
my lord.
It is deemed to be not passed. Then page 59. He again said, I have already passed an order, 16/11.
Yes.
So infractuous, rejected.
Infractuous.
This is out of my understanding. Then thereafter, he should have immediately set aside it, revision petition, but he dismissed it.
Dismissed it.
I am lost.
Yes.
Issue notice returnable in 4 weeks. The petition, as Mr. Sharma has appeared, accepted. Respond number 1, formal notice dispensed with. The petitioner shall take steps for required. Officer in charge?
My lord.
Required.
Officer in charge, my lord, I can represent.
On as both the respondents are represented by the additional public prosecutor, issues of formal
By
notice
name.
to the
By name.
all are formal, not personal, nothing personal.
My lord. Yes, formal.
Dispensed with. Having regard to the reasonings recorded in the orders mentioned above, comma, it is ordered in the interim that the operation of the order dated 15/2/2025 passed by the learned additional chief judicial magistrate Hailakandi and the judgment dated so and so passed in criminal so and so shall remain state until further orders.
my lord, only one thing, my lord, that
I cannot
no, my lord.
allow Jimma now.
Yes, yes, my
Will
lord.
decide.
There is a digital weight machine is also there, lordship. That was also seized, lordship. Along with the seized supari, lordship, there is a digital weight machine.
Okay.
That was also may kindly be mentioned.
ETC করে দিব।
Obliged.
Telling in this is the second, the respondent has filed the second maintenance case, my lord. After that, the dismissal of the first one, my lord. But we'll translate to a time to page number 15, my lord. 51, my lord. It's of the complaint, my lord.
Page 50?
51.
Okay.
Mark number.
What has been granted?
My lord.
You want crossing of this? You want passing of this?
Lordship, we'll turn to page number 55. In paragraph 9, he has said what he has said, my lord.
55.
55, paragraph 9. That the petitioner begs to state that she had filed a petition under the section 125 of the CRPC before the Honorable Mr. Morigaon, paying number so and so. However, the same was disposed on due non-persecution of the petitioner.
Not on merits.
Not on merit, but it was not on merit, my lord, but I'm handing over that order, my lord. It was disposed of on 29/9/2019. Earlier complaint case, my lord. Last, I flagged it, my lord. But we'll see numbers of date all from the website I have taken. And he is not attending the court, man. And he is not attending the court. Thereafter, it has been. What had happened, Malak? This amounts to acquittal. The provisions of the, as per the statutory law.
No, this is what, this is a petition for what?
For maintenance.
125.
125 maintenance. man.
There is no question of acquittal. In a 125, there is no question. It is maintenance.
Maintenance, my lord.
Acquittal results in a criminal case. It is proceeded as per the CRPC, but it is not a case, a criminal case.
If there is a under under CRPC, my lord, under section 378, he should have filed an appeal, my lord. He should have filed an appeal, my lord.
Against 125, no, as per the CRPC. But under section 19(4) of the Family Courts Act, if it is by family court, then it will be revision before the High Court under section 19(4). Otherwise, under CRPC, it is revision because of the non-obstante clause.
That option has
But
not
there
been-
is no acquittal here.
That option has not been exhausted by the petitioner. Now another new case has been filed, man. That's why I'm challenging that how can then a new case has been filed?
That does not differ.
Well, another fresh case after that. This was
And 144B
144
for the illegitimate daughter.
Now this has come at another.
Legitimate or illegitimate, whatever.
But my lord, there another earlier, my lord, the proceeding has been there, my lord.
And what is this? Sessions case?
Session case, he was initially in the trial, my lord.
Nandalal Sarkar.
He was convicted, my lord. Thereafter, it was in appeal, and the revision is pending in the Honorable High Court, my lord.
Oh, why do you should
49,
notice?
my lord. Page 49, that it has been stayed, my lord. It is pending, my lord.
So conviction has been recorded.
Conviction was what it will stay.
So maybe illegitimate daughter, 125B, oh sorry, 144B is for legitimate or illegitimate daughter. Conviction is recorded. 144B. Legitimate or illegitimate. Child. And petition number 2. Will issue notice at this stage, Mr. Ward. Because you have been convicted under 417.
That is cheating, my lord.
Cheating?
Cheating.
What? After entering into relationship. See? Come to base 40. Led to pregnancy.
No.
Your relationship led to pregnancy. That is the finding of the trial court.
Let notice to my lord.
Will issue notice at this stage. Heart, Mr. Asbroal and Counsel for the petitioner. The petitioner has assailed the maintainability, has questioned the maintainability of the proceedings initiated by the respondents, by the two respondents before the proceedings of MR case number 05/2025 initiated by the respondents before the Court of Learned Chief Judicial Magistrate, Morigaon. Issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice upon the respondents by registered post with AD as well as by usual process within 3 working days from today.
Ashit, the matter may be taken up after some time.
No, after the second time, to argue.
Which law score is?
Yes. What is the case?
FIR is page number 13.
ঠান্ডা লেগেছে Nogarbera.
Yes.
What is Nogarbera police FIR?
FIR lordship will find it page 13.
Page 30.
Lordship. May I read it?
Nadir Shah.
Nadir Shah Al.
Offense.
In short, my lord, offense is of my lord 307, but there Taking crossing on compromise, my.
Okay, well, you should notice.
Only notice, my.
Well, you should notice the proceeding state. If it is compromised 307,
There say.
who are the informant?
Zahidul is.
Is he in the petitioner side or the respondent side?
No.
Now? Okay, Zahidul Islam is the informant.
Yes.
Or Mr.
M. Hussein Yalast.
M. Hussein, learned counsel for the petitioners. Mr. MP Gussamil and Mr. MP Gussamil, learned additional public prosecutor for the respondent number 1, State of Assam.
Page 19.
In the first information report was lodged by the respondent number 2 as the informant before the officer in charge Toppamari Police Station on 16/1/2024, naming the petitioner's herein as the assailant of assailants who inflicted injuries upon the informant's uncle, uncle, full stop. It is submitted on behalf of the petitioners that subsequently, the informant had amicably settled the matter with the petitioner side by executing affidavits before the notary. Full stop. In the meantime, upon conclusion of investigation, a charge sheet has been
24.
submitted against the petitioners. Full stop. Seeking quashing, and the case is presently pending before the Court of Learned Judicial Magistrate First Class at Boko in the form of PRC case number 302/2024. Full stop. Seeking quashing and setting aside of the criminal proceedings of PRC case number so and so against the petitioners. The petitioners have sought to invoke the inherent powers of this court under Article 9, Section 528 BNSS. As it is issue notice returnable in 4 weeks. 4 weeks now, I said the order date. As it is projected. Mr. Gusami appear accepted. 1. The petition shall take steps for service of notice upon the respondent number 2 by registered post with AD as well as by usual process within 3 working days from today. The petitioners have annexed 2 affidavits, copies of 2 affidavits which are shown to have been executed by the informant.
Another victim. Another affidavit victim.
1 affidavit or 2?
2 affidavits.
2 affidavits.
One is informant.
Stating that the matter has been amicably settled by the informant as well as the injured with the petitioner side. So, having regard to the same, it is ordered in the interim that the proceedings of PRC case number so and so presently pending before the Court of Learned Judicial Magistrate First Class Boko shall remain suspended till the returnable date.
Okay.
Yeah, please, ma'am. My lord, by the impugn order, my lord, my prayer for interim custody of the vehicle rejected, my lord. My lord, impugn order is at page 19.
We'll call for a report.
No, sir.
Will issue notice at Mr. A.K. Gupta, Learned Counsel for the petitioner. You were a registered owner?
Yes, ma'am.
and Mr. MP Goswami, learned additional public prosecutor for the respondent state. Full stop. The petitioner has claimed that she is the registered owner of two vehicles bearing registration number file over here. Page 12 for us. When a petition for interim custody of the said two vehicles was prepared by the petitioner before the Land Session Judge Ibohagor, the said petition says the said petition for interim custody was rejected by the Land Session Judge Sibsagar by the order dated
27/2020.
by the impugned order dated 27/2000 by an order dated 27/2025, impugned herein. Full stop. The said two vehicles have been seized in connection with Sibsagar Police Station case number 88/2025. UAP Act.
VP.
Okay. Issue notice returnable in on so and so date. As Goswami.
Yes.
The other additional public prosecutor is to obtain a report as regards a requirement of keeping the vehicles as regards for the trial and to place the same on the next date of listing.
Yes.
Yesterday matter, my lord.
Yes, anything.
I have gone through, my lord, the order impugned, my lord, pursuant to, my lord, 36A4, my lord. That is not correct, my lord. My lord, the application filed by the IO, my lord.
Any role PP played? No.
PP, there is no mention in the order, my lord.
Hmm.
I have gone through the order.
Itu core আছিল ন? Itu এই মাত্ৰ দিছিল এছ বৰা
But public prosecutor will have to submit the report, my lord. Public prosecutor will have to submit the report, my lord. By my lord.
IO can submit it to the
Public
PP.
PP.
Thereafter PP with his application in mind and with his experience, he has to submit a report before the court. And court is required to take note of that report, not of the IO. I think that is the provision, statutory provision,
very
and
clear.
that is the law explained. Law explained.
Yes, my lord.
There is no escape from it.
No, my lord. Provision is very clear, my lord. 36A4.
When a procedure is laid down about the manner in which
my lord,
prayer for extension is to be made, then that particular mode is to be done in no other manner. Hard. Mr. J.C. Bora, Learned Counsel for the petitioners, and Mr. R.J. Borua, Learned Additional Public Prosecutor for the respondent state of Assam. Full stop. Para. Before. Dilating on the impugn order dated. Before examining the legality and validity of the impugn order dated 20/01/2025 passed by the Learned Special Judge, Morigaon, within bracket the special court for short, comma, it appears apt to alienate the necessary and relevant facts leading to the passing of the said order. Full stop. Para. And a first information report was lodged by a sub-inspector of police attached to Borsola outpost, Morigaon, before the officer in charge, Lahorighat Police Station, Morigaon, on 24/7/2024. And in reference to Borsola outpost, Lenel Diary entry number 305, dated 24/7/2024. Full stop. In the FIR, it was stated that it was entirely stated that an information was received from a reliable source on that day that one person named Amjad, AMJAT Ali, had taken a huge quantity of suspected heroin to the house of one Abdul Hassan, village Lahorighat, in order to smuggle. Full stop. Upon instruction, a police team led by him proceeded from the outpost to the house of Abdul Hassan in order to conduct a search. Full stop. A search was thereafter conducted in the house of Abdul Hassan in presence of independent witnesses at around 1:20 a.m. under videography. Poster. The alleged drug peddler, Amjad Ali, was found inside the house. Poster. During the search of the house of Abdul Hassan, 71 number of soap cases containing suspected heroin was recovered, with one heavy-duty digital weighing machine from one Zinatul Islam in presence of witnesses. Thereafter, the two accused persons, namely Amjad Ali and Abdul Hassan, were caught red-handed with a huge number of NDPS items. Full stop. On women, comma, the suspected heroin, net weight of suspected heroin was found to be 850 grams without plastic soap cases and 2.862 kgs with plastic soap cases. Full stop. One, vehicle bearing registration number AS-03T-1533 were also seized along with other items. Full stop. On the basis of the said FIR, comma, Lahorigarh Police Station case number 152/2024 was registered on 24/7/2024 for offences under section 21 within bracket C stroke 29/25 of the Narcotic Drugs and Psychotropic Substances Act 1985. Post of after being so arrested, comma, the two accused persons, namely Abdul Amjad Ali and Abdul Hassan, that is the petitioner's herein, were forwarded to the Court of Learned Chief Judicial Magistrate for production, and on being so produced, comma, the two petitioners were remanded to custody on 25/7/2024. Remanded to custody on 25/7/2024. Full stop. The petitioners have averred that since 25/7/2024, they are in custody till date, right?
Yes.
Okay, full stop. Para. On 20/01/2025, comma, the accused petitioners were produced before the learned session, a special court from jail custody. Post of para. On prior to 21/2025, comma, the investigating officer of the case had submitted an application on 18/1/2025 with a prayer for extension of the period of investigation. Post of. The said application was submitted purportedly under the proviso to subsection 4 of section 36A of the NDPS Act. Full stop. Application is available here.
That is the application, madam. Page 21.
In the application dated 18/1/2025, comma, annexed as Annex 3 to the instant revision petition, comma, the IO was found to have mentioned about the steps taken by him during the course of investigation carried out by him till 18/1/2025. Full stop. The application mentioned about the article seized by him during the course of investigation. Full stop. He stated that contraband suspected to be heroin, weighing 850 grams was seized. When a search operation was conducted in the house of Abdul Hassan, within bracket, the petitioner number 2. Full stop. I further stated that the complaint informant and the witnesses were examined and their statements were recorded under section 188B and SS. Most of the statements of the accused persons were also recorded under section 188B and SS. Full stop. Samples were also drawn for sending it to the Directorate of Forensic Science, Assam, Guwahati. And the samples were forwarded to the Directorate of Forensic Science, Assam, for expert opinion. Full stop. Stating that the investigation is pending for non-receipt of the forensic forensics report from the Directorate of Forensic Science, Kailipara, Guwahati, Assam. Layo, in his application, made a prayer not to grant bail at such stage of investigation. Post of the IO had made a further prayer to extend the period of investigation till receipt of the forensic report in the interest of investigation of the case. Post of the application was addressed to the Learned Special Court through the PSI Court, Morigaon, on 18/1/2015. Full stop. On submission of the said application, above referred application, the Learned Special Court, on 18/1/2015, heard the learned public prosecutor and the IO of the case on the application praying for extension of the period of investigation under section 36A within bracket 4 of the NDPS Act. full stop. By order dated 81/2025, comma, the London Special Court directed the directed to inform the learned counsel of the accused petitioners about the prayer made by the Invest IO for extension of the period of investigation. Full stop. A copy of the said order was ordered to be sent to the learned counsel for the petitioners. Hafizur Rahman was your counsel?
One of the counsel.
Full stop. The learned special court posted the case on 20/01/2025 next for hearing on the prayer for extension of the period of investigation. Full stop. Para. On 20/01/2025, the London Special Court has passed the order, comma, which is impugned herein. Full stop. The relevant excerpt for ready reference, comma, the relevant excerpts of the order dated 20/01/2025 are reproduced herein page 24 to 25. Para. So, Section 36A of the NDPS Act has prescribed for the trial by special court for offenses under the NDPS Act. Full stop. Subsection 1 of Section 36A is with a non-obstante clause. Full stop. As per clause A of Section 36A within bracket 1, all offenses under the notwithstanding anything contained in the Code of Criminal Procedure 1973, all offenses under the NDPS Act which are punishable with imprisonment for a term of more than 3 years shall be triable only by the special court constituted for the area. Full stop. As per subsection 4, comma, in respect of persons accused of an offense punishable under section 19 or section 24 or section 27A or for offenses involving commercial quantity, comma, the reference in subsection 2 of section 167 of the code, comma, thereof, to 90 days, quote unquote, comma, where they occur, comma, shall be construed as reference to, quote unquote, 180 days. Full stop. The proviso to subsection 4 of section 36A has provided that if it is not possible to complete the investigation within the said period of 180 days, comma, the special court may extend the said period up to 1 year on the report of the public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period of 1 year and 80 days. Full stop. As per the schedule to the NDPS Act, a quantity above 250 grams sorry. Is falls in the category of commercial quantity, right?
Yes.
In such view the matter, comma, the provisions contained in section 36A within bracket 4 and the proviso thereof are found applicable in the case in hand. Full stop. Therefore, comma, the maximum period of 90 days fixed under section 167 within bracket 2 CRPC has been increased to 180 days. In case of offenses involving commercial quantity under the NDPS Act. Full stop. The proviso to section 36A4 has further authorized has prescribed a further period of detention which can go up to beyond 180 days and up to 1 year, comma, meaning thereby, comma, up to 1 year. If the special court extends the period of investigation exercising the power under the proviso to section 36A within bracket 4. Full stop. As a corollary, comma, the period of detention of an accused person involved in a case arrested in connection with a case involving commercial quantity can be extended up to 1 year with the modified provisions of section 1672 CRPC. Post stop. Para. It is specifically prescribed in the proviso to subsection 4 of section 36A of the NDPS Act that an order of the special court extending the period of investigation beyond 180 days and up to 1 year must be preceded by a report of the public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period of 180 days. Full stop. It is the NDPS Act is a special annexment providing for severe, stringent punishments. Full stop. It is right to observe that the stricter the severe the punishments, the stricter the provisions are to be, stricter is the compliance. To hold it 20. Para. In the reverting back to the facts of the case in hand, comma, it is found that there was no report of the public prosecutor seeking extension of the period of investigation and indicating the progress of the investigation. Full stop. It was only on the basis of an application submitted by the IO of the case, comma, addressed directly to the session judge or to the special court, to the PSI court, comma, the order impugned, the impugned order dated 20/01/2025 came to be passed. Full stop. It is specifically, it is reflected in the impugned order dated 20/01/2025 itself that it was the IO who had prayed for extension of the period of investigation beyond the period of 180 days. Full stop. The special court has also recorded that on 20/01/2025, comma, the accused persons completed 180 days inside the custody. Full stop. It was only on the basis of the report of the IO and the stage of investigation, comma, the special court, comma, by its order dated 20/01/2025, comma, allowed the prayer of the IO by allowing the extension of the period of investigation for a period of 90 days from 20/01/2025. Full stop. Para. It is apposite to refer to the observations made by the Honorable Supreme Court of India in Sanjay Kumar Kedia alias Sanjay Kedia versus Intelligence Officer Narcotic, refer to the observation. To ensure 2009-17 SSC 631. Full stop. Para? Para, Mr. Bora?
Para, my lord, para 18, my lord. 18, 21
18.
and 22.
Wow. আগতে লিখি দিব আগতে লিখিব তাপেৰা the conditions provided conditions to be fulfilled as per the proviso to subsection 4 of section 36A of the NDPS Act, for extending the period of investigation beyond 180 days are para 12 আছে 1 2 3 4 1 2 3 4 আছে para 12 বুঝছে para 18
Para 18, my lord. 1821.
Okay, law in this condition has been settled by the Honorable Supreme Court of India in so and so. Sanjay Kedia, huh? it is settled that when the statute prescribes, Nazir Ahmed line, as no prayer, as no report was submitted by the public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the period of 180 days to extend the period of investigation beyond 180 days before the Learned Special Court, the Learned Special Court could not have derived power, authority, and jurisdiction to extend the period of investigation beyond 180 days on the basis of solely on the basis of an application submitted by the investigating officer of the case. In such view of the matter, the order dated 20/01/2025 is found unsustainable in law, and the same is liable to be set aside, and it is it is accordingly set aside. Resultingly, the instant criminal petition stands allowed.
Reply apply.
Colleagues. Yes, we will call for the case there.
My lord, in this case, my lord, allegation against me.
We'll
my lord,
call
only-
from which North Salman or Abhayapuri? Yes, what is the date?
My lord, I'm just subject to the permission of this one, my lord, online submission. Allegation against me, I have demanded money from my own father. On that case, my father is the accused, my lord. Kindly see page 22, my lord.
We'll call for the case there, Mr.
Fifth, my lord.
Fifth. Third, Mr. A.K. Azad.
Yes, sir, my lord.
A.K. Azad.
A.K. Azad.
Counsel for the accused petitioner, and Mr. Swens. 439, 483, See, BNSS. Abhayapuri Police Station, so place the case on 8 August 2025 to enable the learned additional public prosecutor to produce the concerned case diary. Same. 39.
Item 15. 39 also same matter.
Already ordered,
From the
same.
15.
Somebody was.
Lordship. Lordship, I am the respondent number 2, Manish Kumar Agarwal in person, Lordship.
One minute.
Lordship.
Hey, Harry. One minute. So. To take over. Okay. Yes.
Lordship, may I?
Yes, please.
Lordship, the brief facts of the case is that I am the
No.
informant of an FIR registered in Dibrugarh pending since 2018. The accused is the petitioner here. He comes to this court for anticipatory bail. He attaches a forged document containing my forged signature. I file an FIR in Latasil police station because Latasil has the territorial jurisdiction over Guwahati High Court, and I file an affidavit. Now that FIR has culminated into a charge sheet that the petitioner has done fraud on this court by attaching a forged document. Cognizance has been taken.
Please.
Summons has been issued.
Please, please. Mr. Gupta.
Agarwal, Lordship.
Agarwal. Mr. PP is the party. Yes. Are you ready? It is a quashing. And what is your prayer?
Lordship, my commission was that today I was seeking for adjournment because
You are Mr.
M. Bosumotari and guest counsel R. Sonar could not come today. He's supposed to come from Arunachal.
Lordship, may kindly hear me for a brief moment, Lordship, how a palpable fraud has been played on this court, and then my lords will take a call.
No, Mr. No point hearing only you.
Lordship.
Whether Mr. PP, are you conversing with the facts? Are you conversing with the facts?
No, my lord.
Because LCR or something is
Yes.
available.
Lordship.
I
Scan
have to go
copies or whatever. Mr. Sharma,
My lord.
just see this order, thereafter we'll proceed. I think it has not been listed for about 1 year.
10 months, 2 days, Lordship, approximately.
Okay. I said about 1 year.
Lordship, that's it.
Such precision is not required for unnecessary things.
Lordship. I apologize, Lordship.
Okay. So, Mr. Sharma, you have to go through the case record. This is the copy of the record
My lord.
for assisting the court. So, packet আছে না? Yes, Mr. Agarwal.
Lordship.
Will post it an agreeable date for both of you.
Lordship may post it to Lordship's convenience, but I have a very humble prayer, Lordship. The interim stay was valid up to 27th of September, and on 27th, the case was adjourned for verdict. So, the interim is not there. It
We
can
are
kindly
not
be
going into
reflected.
detail, Mr. Agarwal. Some exceptional situation. We'll post it on immediate. Yes, Mr.
5th of
Bosumotari.
August.
When Mr. Arguing Counsel will be available?
5th of August.
Lordship, the trial court is due on 4th, so it can be on 1st of August to Lordship's convenience, because the matter is
So
pending
you
for the
are
last 2
asking
years.
for convenience. It is not convenient up to 9th of August, only beyond 9th of August. So anything after 10th of August. Oh, sorry, not 10th, 11th of August.
Lordship,
11th of August.
Can it be on August 26th, my lord?
11th is very
No,
well,
beyond
but is
11th
the
of August.
interim lordship can be mentioned? Lordship's
I'll not
convenience, I
observe
am,
I'll not
I am
observe
available
anything,
then.
Mr. Agarwal.
Lordship,
19th of August.
19th.
19th of August, we will post the case.
Lordship, in that case, can it be 25th? Because on 26th, there is another matter in this court.
25th is holiday.
25th is holiday. It can be on 27th, Lordship, if it is possible.
Okay, 27th.
Lordship, on 26, it can be 26 because our Sonar have another matter in this honorable court. Can be
We
available.
are not, do not like to accommodate in such a manner. 27th.
Interim may continue.
Lordship, there is no interim.
We
Interim
will
has
not
lapsed.
observe anything. We will not observe anything. Mr. R.M. Boshumatari, Learned Counsel for the petitioner, has submitted that the arguing counsel, Mr. M. Boshumatari, is out of station and has thus sought for listing of the case on another date. Full stop. Mr. B. Sharma, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, and Mr. M. K. Agarwal. You are counsel or in person?
I'm in person, Lordship.
Okay. The MK Agarwal, the respondent number 2, in person through video conferencing. Hard লিখে দিব. As sought for by Mr. Sonar, counsel for the petitioner, and as agreed to by Mr. Sharma and Mr. Agarwal, placed the case on 27/8/2025. 27/8/2025.
Lordship.
In the admission column. Mr. Sharma, you go through the records.
Petition Lordship. Petition under 528. One of the brief facts of the case is that respondent number 2.
Yes.
Respondent number 2, my lord, involved in actively in occupation of trading, my lord, has invested some money, some person, my lord. Here the respondent number 2 has came to the branch of the petitioner.
This is
has-
what the prayer is what? For quashing?
My lord,
Quashing?
my lord, quashing and modification. What has happened, my lord? After depositing the money, my lord, which the lordship will find at page 51, my lord.
Yes.
One of the respondent number 2 has visited the branch of the petitioner, my lord, the XDFC
No,
Bank.
tell me the story first.
And here, my lord, what has happened, my lord, the respondent number 2 was actively involved in the occupation of trading and businesses, my lord, has invested some money. He has come to the branch of the petitioner, duly acknowledged.
Branch of the petitioner, who is the petitioner?
HDFC Bank Limited. The Fancy Bazaar,
Branch of the petitioner, which branch?
Fancy Bazaar branch.
Yes.
My lord, he has deposited and transferred an amount of rupees 50 lakh to some one person, Khodia Garage Auto Limited, on 14/5/2024. And thereafter, my lord, after 3 days, maybe he have realized that the person to whom he has transferred the money, the fraudulent, he has filed an FIR before the police station that he has been cheated by some fraudster and all. So he has filed the FIR 3 days after transferring the money. So the what happened, the respondent number 1, immediately after the lodging of the FIR, have given us the email to debit freeze the account until further orders. So accordingly, we have debit freeze the account. And then after a few months, my lord, again another email was sent attaching the order of the SCM2, whereby it was to say that the transfer amount of rupees 6 lakh to the respondent number 2. But here the problem is, when the amount was deposited, the 50 lakh on, when if your lordship may come to the
Point number two. Okay.
Lord, when the amount was deposited, on the same day, my lord, the amount was withdrawn. The amount was deposited to the branch in Mahua in Gujarat, my lord, transferred. Now, on this same day, the amount of rupees 50 lakh was withdrawn. So on the day in which the petition respondent number 2 has deposited the amount of 50 lakh, it has already been withdrawn. And on the next day, my lord, again thereafter, several again credits were there. So ultimately, there were around 27 notices from all the police stations, my lord, including all the states, from Maharashtra to Rajasthan, from Tamil Nadu to Jammu Kashmir, to debit freeze the account. And accordingly, my, there are also several other court orders from Bangalore as well as Rajasthan to refund the amount of so and so, like 1,50,000 to him. But the thing is, my lord, here the concerned case is the respondent number 2 have deposited an amount of 50 lakh, which has already been withdrawn. Now, whatever amount is left, around 8 lakhs is there in the account. And there are different multiple attachment orders, there are multiple court orders from different investigating officers, my lord, to block the account and to transfer the amount. So, we are not able to implement any of the orders. Here, we are challenging the order of the Learned Court below, because without even confirming to the bank statement, have directed the petitioner to refund the amount from Mahua branch to HDFC to the account of the respondent number 2.
Mahua branch of which bank?
In Gujarat, ma'am.
Which bank?
The same bank, ma'am.
Same bank?
Same bank. HDFC same bank. But there was no connivance on the part of the official, ma'am. No report as such. The thing is that the amount which
So
was...
it was transferred to Mahua branch
Yes.
in a particular bank account.
In a particular bank.
So it is there in the account.
No. The amount which was transferred on that day was already...
This man deposited 50 lakhs.
Yes, ma'am.
At Fancy Bazaar branch.
At, deposited Fancy Bazaar branch, transferred to the Mahua branch in Gujarat. Same bank. He himself came to the branch and he has deposited. The acknowledgement slips were there. But if your lordship may come to this statement of account...
He deposited in an account which is maintained in Mahua branch.
It was the account holder. The account payee holder. It was in the Mahua branch in Gujarat. So, 50
He
lakh...
deposited in that account.
Yes, in their account, ma'am. So, the alleged fraudster account, ma'am. And the 50 lakhs was also withdrawn on the same day. And if your lordship may come to the statement of account, ma'am, at page 55, ma'am.
Now, what is here order? What is the order here?
Man, order, my lord, your lordship may come to page 44, my lord. Sorry, my lord, page 39 it starts. The operative portion, my lord, at page 40, my lord. The bracket, my lord, down below. And here, my lord, amount on hold, this is the account. And page 41, my lord, order. After passing of the order, my lord, the bank have also approached the concerned magistrate, my lord, and appraised all the facts. But however, since the order cannot be reviewed, my lord, so it was not recalled or reviewed, and which your lordship will find at page 106. My lord. 106.
No, by this page order at page 39, the complaint was simply directed to approach the court seeking refund. Nothing has been ordered against the bank.
Yes, my lord, that have been ordered, but it on the amount.
No,
We approach the amount, and we have
the
accordingly.
magistrate SDJM has not passed any order.
My lord,
Come to page 41.
yes, ma'am. In clearance, so I will approach the court and then refund the whole amount. The week. How many approach it, they will not know. As per the provision. Also,
Now let us understand. Account number 905.
number one has directing us to the loss.
So see the order first. First let us understand the order. Page 40. The court analyzed the statement of the fraudulent accounts. And court acknowledged that monies were transferred from those accounts. Then it recorded at 1 and 2 how much amount, after being instructed by cyber police, has been put on hold. 1 and 2. Then there is a table, amount on hold. Then hence, last para, raised to pass an order for reimbursement of the hold amount. Hold. Hold. Please understand and make submission. Whole amount, meaning thereby 6,32,000 and 5,01,000. Right? Whole amount and direct the response, IO praise. This is IO praise. IO praise. And court did not allow that. Court directed the complainant to approach the bank, right, regarding refund of the hold amount. This is the order. We are not concerned with 50 lakhs. We are concerned here with 6,32,000 and plus 5,000. Let me understand. Yes. You started with 5 lakhs. You never mentioned about 6 lakh and 5,000. 5 lakh. Right? And court has not passed any order directing the SDFC Bank in this order. If I have understood correctly. Right? And what is under challenge here?
I may.
What is, let us see. You make submission, but if there is unnecessary submission, will not. Stay the further proceeding of cyber case number. How can you say for cyber PS case number should be stayed? Who are you? The case is not at the insistence and not against you. This interim prayer, we don't find anything. Impugn proceeding of cyber PS case number so and so, cyber PS. Why? What you are seeking? Omid Chaudhary lost the affair. He lost the affair perhaps? Where is the affair?
Page 19.
And whatever you are one of the medium
Lordship,
to which the fraud has been perpetrated.
Lordship,
You are one of the medium,
Lordship,
and there is no direct allegation perhaps
Lordship,
against you.
Lordship,
But since you are of the medium, one of the medium
Lordship,
through which fraud has been perpetrated,
Lordship.
how can you make this prayer in this criminal petition?
I mean,
Who are you? No, prayer. Come to your prayer. Who are you?
I'm the-
What authority
I've been
you have?
supposed to comply with the order.
Come to 7. Where is this order for compliance? Show me. You have taken me to the impugn order. That is what? After reading it thoroughly, what 160?
Page number
Where is the 4-6 order once again?
order. And 190.
1 minute. Let me mark it. Page 40. And next one is 1911-2024. What notification 67?
I have the
Is
appeal.
106. What is notification number 6?
Notification issued by the Honorable Court Lordship that
Let us
no,
see.
no FIR is required to hand over the frauded money.
Notification.
Lordship, second paragraph, the trial court are direct not to insist on registration of a FIR in the matters which has already been registered online National Cyber Crime Reporting Portal in cyber frauds and crime.
These two orders are not matching.
Lordship,
These two orders are not matching.
Lordship, this
The earlier order at page 39.
Lordship,
and this 1911, 2024 are not matching, not telling with each other, cannot go together.
Lordship, when the banking authority did not comply with the order passed by the learned trial court, Lordship, another petition were preferred by.
Okay, non-compliance, it is not non-compliance. Where is the non-compliance?
As because.
Is
Lordship,
directed to approach regarding
we have
refund.
approached both the banking
With all the
authority.
necessary documents, and the bank shall do the needful as per proper procedure of law. But if it is already under lien,
Lordship, there are two banking authorities are there. One is
we are
HDFC Bank.
concerned with only this one.
Another is
Fancy
IndusInd
Bazar
Bank.
branch, we are concerned with, we are not concerned with others.
That bank has already been complied with the order passed by the learned trial court, Lordship.
What?
The Indore Airport Road, Indore branch of the IndusInd Bank, there are two banking authorities are there, Lordship. Kindly peruse your Lordship. The order passed on that 17/5/2024 Annexer 4, page 39, Lordship.
It
The
is
imping order-
4/6/2024. Page 39.
Lordship, imping order passed by the learned trial court, imping.
No, it is Cyber Police Station GDNT number so and so dated 17/5. Order is dated 4/6/2024.
2024.
Please.
The order passed by the learned trial court on 4/6/2024 on both the bank, Lordship, and the one bank has already been complied with the order passed by the learned trial court, Lordship. The IndusInd Bank, Airport Road, Indore has already been complied.
No, Mr.
But so far as the HDFC Bank is
Mr.
concerned,
Agarwal,
Lordship,
Mr. Agarwal,
Lordship.
this man is from Gandhi Bosti, Guwahati,
Lordship,
right?
Lordship,
Whatever amount he invested,
Lordship. Some part of the amount has been transferred to these two bank accounts.
these
has
two
been-
bank accounts,
These,
somehow it went to that.
you
You,
Lordship,
you used this Fancy Bazar branch
Lordship,
of bank,
Lordship,
right?
Lordship.
So ultimately on inquiry, two amounts were found on hold
Lordship,
at two different branches
Lordship,
after being instructed by Cyber Police Guwahati,
Lordship,
right?
Lordship.
So, and out of these, there are two tables.
Lordship,
HDFC Bank,
Lordship,
that is Nutan Nagar branch, you received?
Lordship, the Nutun Nagar Mahua.
You
Is one-
received? You did not receive.
Did not receive as Lordship, the order passed by the learned trial court.
No, trial court did not pass any order. Don't try to misinterpret.
Lordship,
IndusInd Bank you received.
Lordship,
5 lakh you received.
I received.
Right. HDFC Bank, there was a hold amount of rupees 6,32,820.
Lordship.
So
Yes, sir,
what is the operative part of the order? Page
Lord-
41.
The last three line is the operative portion. The informant is to approach the concerned bank.
With all the necessary, bank shall do the needful as per proper provisions of law. There is
nothing.
There is nothing, Mr. Agarwal. Don't try to.
No.
There is nothing, no direction.
No, such
Do
direction.
the needful.
Lordship.
Then ultimately it reached the situation at 1911. Page 106.
Lordship. Learned trial court has
Learned trial
clarified-
court, what the learned trial court has held?
clarified that we have passed the order in terms of the notification number 67.
By that way, you cannot modify. You cannot modify this order, what he has observed in the last paragraph. In the first two paragraphs, he has completely did that. Last paragraph, he said, as a criminal court, it cannot review its own order. Right, Mr. Agarwal, please.
Lordship.
By raising the voice, the law cannot be changed.
No, not at all. Yes, Lord.
Please keep in mind.
Lordship.
So, keeping in view section 362 CRPC,
Lordship.
the court has observed that I cannot review my own order.
order.
The earlier order will prevail.
Lordship.
Now, but in the preceding two paragraphs, what he said, he brought in notification number 67,
Lordship.
as if he's directed release of the amount. But he did not direct release of the amount. This has to go. What is not said directly cannot be said indirectly by way of clarification in a subsequent order. He himself said, 362, I cannot review my own order. But what he has introduced? Notification number 67, as if he directed release of the money on hold. I don't think that is the interpretation possible if we read this order along with the previous order. But what you have challenged? Problem is there also. Which proceeding?
Not being called upon. Problem is the whole amount, my lord. The whole amount doesn't come to the response.
No, this order, Mr. Smith, it is not 50 lakhs. Don't try to broaden the scope. The order is 4/6/2024 was in respect of whole amount, not the entire defrauded amount, which has been not been possible till date to recover. But what has been put on hold? This order is pertaining to that amount. Don't try to, both sides are trying to prevail upon one another. Think it over, I may set aside this next order, 1911, it goes out of hand. Because they are also bound by other orders. But where are the other orders?
My lord. Order. Order.
It has been put on hold perhaps. Which account? SDFC. Which part?
Column 6.
20 or 2 lakhs? Be sure.
Sorry, my lord. From the court of the case of Bangalore. My lord, the next page, my lord. Why? There are, my lord, also Kerala police.
Yes, Mr. Agarwal.
Lordship, so far as the amount is concerned, Lordship, which has been held by the cyber crime, the Assam police, Lordship, that has been first charge was of the petitioner, Lordship, the respondent, private respondent number 2, Lordship. And on the basis of the Lordship, the police report, the imping order was passed by the landed trial court, Lordship.
Okay. Day after tomorrow, we'll pass the order. M. Smith. Yes, Mr. Sharma. What do you have to say? These are orders passed by cyber police. What do you have to say? Huh? No, you are also making orders. You are also making orders. Release the money, release the money. Without knowing that every entire amount has gone out. Where from the bank can give? Whatever is retained and put on hold, that can be released. And P. Sharma, Learned Additional Public Prosecutor for the respondent number 1 state, and Mr. S.K. Agarwal, Learned Counsel for the respondent number 2. Not present. This here is, was it? only 2012, 13. We'll put it on Monday. Oh, sorry, Tuesday. Next Tuesday. Next Tuesday, Kidai? 5. 5? 5.
Deeply obliged. Obliged, Lordship.
This case, I have taken instruction, confiscation has been initiated and the petitioner has replied. I don't have at my hand now.
Get a written instruction.
Yes, my lord.
If
The
confiscation
yes,
proceeding
my
is
lord.
initiated.
Bring it, my lord. The DFO is busy with the eviction today.
Okay, when do you want?
Next week,
Forest Act.
AFR,
Hmm?
Assam Forest Regulation.
Orchid's present petitioner, huh? On the request of Mr. D. Goyal and Special Public Prosecutor Wildlife, place the case on next Wednesday. Eviction will be over.
I think so.
Okay. No,
It's a
otherwise
judgment,
Friday.
my lord, once it's
Friday,
commenced.
Friday,
My lord.
Friday, next Friday. Not this Friday, next Friday.
Next.
Hmm. Your name, please. J.P. Goyal and Counsel appearing for the appellant. As by referring to the law or order dated 25/7/2025 of the law Jima Court, has paid for 2 days time to take so or law Jima order 16/7 has paid for a last opportunity of 2 days, 3 days to take steps for service of notice. I'm on the respondent number 2. First of the prize allowed, Mr. Olva is present. Release the case after 4 weeks. After Koridun Duta. Same age does. Next time, Mr. Das, if you don't take steps, your appeal will be dismissed. Somehow or other, on merit.
Very please, my lord, I have filed an affidavit in this matter, my lord.
You have order?
My lord.
Some other day then.
Yes,
Already we are almost.
Maybe 5th or 12th. Subject to
No, we are not very
5th or 12th.
favorable till 8th of August, 8th or 9th of August. Thereafter, we are free.
5th.
Yes, choose a date after that,
Keep it going.
9th of August. 15th August, no? Oh. 18 August, 18. M. Kumari. You are for whom? CBI. And Mr. Das, DK Das, you are for whom?
I'm opposing the.
You are opposing?
I'm opposing.
Private? Okay, I thought that you were for.
My lord,
Okay.
can
For
it be
the opposite parties.
Can it be on
Are
17,
present?
my lord?
17?
17.
18.
18.
17 is Sunday. Next. Okay, not possible.
Obliged.
We'll put, who is for, who is in item number 25? Oh, no.
My lord, one day should appear, learned access.
This is a case of 2012. It is staring in our face,
Yes, yes.
right?
I think, my lord, these can be disposed of, very limited question, but lordship has to fix some other day because.
That is why I have called both of you.
Yes.
To dispose of at the earliest.
Yes, yes. Very
Because
limited
13
question.
years have gone by.
Because, my lord, the scope of 397,401 is
Okay.
nothing else.
It will deduct 18 or deduct. 18 is Tuesday, no? Then 18. Oh no, 18. You can put it on 11th. Oh, sorry. 12 August.
12 August. my lord.
12 August. Mr. A. Chaudhuri.
Yes.
Petitioner. D. Gogoi, amicus.
I am for the petitioner.
Yes,
I am for the petitioner.
Amicus present as sought for 11, 12 of August. Are there any this orders matter? We'll post it on some other day. Not no prayer for hearing matters.
Item 24, my lord.
24 is orders matter.
Orders matter.
Okay, it will
In
be
next-
posted. A date will be given.
Yes, ma'am.
Order matter date will be given. যোনে যোনে বিচাৰে দি দিব অৰ্ডাৰ কেইটা যিবোৰ আয়ে আছে ন এটা দি দিব not hearing matters, no hearing, only orders.